Hello, hello,
hello. They're all here. Great. What a conscientious group.
We've got a pro se train wreck. It's Alyssa's fault.
Thank you. I do have more info. Well,
Give me a sec. We'll get on the record on several things we need to cover. Got to mute myself first here. There we go. Okay, before we go on the record, do you both have the Zoom link for today?
Yes, I have.
So you can log in. You should log in before the jurors come out, just so your machine can be connected and we can shut off the echo loop if there's an issue with the speaker. Great. All right, while you're doing that, we'll get on the record. Now that our court reporter made it through the fortress. We are here on 2023 CV 386362. It's Christopher Pope versus MARTA. Mr. Pope is here. He is pro se. Ms. Lewis is here representing MARTA, and MARTA's agent, Mr. Ennis, is here as well. Yesterday, we picked a jury very efficiently and then went through a lengthy discussion on motions in limine that MARTA had filed. I asked for jury charges. It looks like both sides have gotten them to Ms. Niles, so she can work on a draft jury charge that I'll circulate once she's done. We left hanging a couple of questions that the two sides were going to work on over the course of the evening that I want to revisit. And let me do that so we've got a good view of the courtroom. And we had one development with a juror that I'll discuss with you all in a moment. Let's start with, in no particular order, medical records. Mr. Pope, did you get to Ms. Lewis the medical records that we were discussing? And I appreciate it may have been the second time you think you sent them, but my request to you was to identify where in your exhibits or at least your intended exhibits, you had medical records that you were thinking about admitting. Make sure you got them across to Ms. Lewis. Did you do that?
Oh, no, sir.
Okay, how come?
I didn't, I may have thought I sent it to her. No.
You thought last night you sent them to her?
Yeah, after I checked, I didn't send it. You know, I thought it was a part of my exhibit.
Okay.
Yeah.
I just want to make sure I'm following. You understood yesterday when you left that I had asked you to send them to Ms. Lewis.
Yes.
Okay, but you did not do that.
No, after I checked, I'm saying the exhibits I sent, I looked over them and it wasn't a part of it.
Oh, you went and looked through all the things you had previously provided. They weren't in there, so you're backing off those.
Yes, yes,
Okay,
sir.
got it. So no medical records. Again, that doesn't mean you cannot talk about what you experienced.
Oh, yeah, yes,
We've been real clear about that. You can say, I went to a counselor, I went to a doctor, where there may be objections that I would likely sustain would be if you start getting into what the doctor told you.
Right, right.
Okay, good. Anything, Ms. Lewis, you want to get on the record concerning medical records given Mr. Pope's announcement? Next topic was union reps / shop stewards. And that was of interest to me because we were working through the relevance of Mr. Royal's testimony and Mr. Gresham's testimony.
Sorry, I just want to invoke the rule again. I'm not sure.
Are you Mr. Gresham? Hey, Mr. Gresham, good morning, sir. So unless Mr. Pope has released you as a witness, I need you to wait outside. He will get you soon because he's going to be able to start calling witnesses probably in about a half hour or so after we get the jury in here, et cetera. If Mr. Pope has told you you're not testifying, then you're welcome to stay in here. Mr. Pope, what is Mr. Gresham's status?
Oh, yes, he's testifying.
Okay, then we're about to talk about you and your testimony, so I need you to step outside. Thank you. Thank you, Ms. Lewis, for flagging that. So we discussed yesterday afternoon the connection that Mr. Royal and Mr. Gresham might have to Mr. Pope's situation. And what I thought you said to me, Mr. Pope, and I may have misunderstood because I was learning new terms like see me sheet meeting or show me sheet meeting, all these terms unique to life as a MARTA employee. But I thought you told me that Mr. Gresham and Mr. Royal, along with being maybe friends and coworkers and whatnot, they could talk about your situation and your complaints against MARTA because one of them, maybe not both of them, but in different sessions, each of them had been your shop steward or union rep when you had the disciplinary meetings or the show me sheet meetings with MARTA people. Am I remembering correctly that that was their connection to your situation?
Yes, Mr. Royal won't be here today.
Okay, you've excused him?
Yeah.
Okay. All right, so we're back to Mr. Gresham, who is here.
Mr. Gresham, who's here?
Okay, and you're saying that he was present for one or more of the show me sheet meetings you had?
Well, he present to testify.
Okay.
Same as Mr. Gresham. But
I've got
for personal
context.
reason, he's not. From my understanding, he's not coming.
Mr. Royal's not coming.
Yeah, from my
Well, Mr.
understanding.
Gresham's here.
Yeah.
And if you're going to call him as a witness, I need you to tell me not every word he's going to testify to, but what's he going to talk about generally?
He's going to talk about his service with the company. I have questions.
I'm sure you've got questions.
Pertaining to medical, anything medical.
Pardon me?
It's not pertaining to anything medical.
Okay.
I understood you yesterday when you told me.
Good. And we got that part. But another thing I told you is that it would not be proper testimony for Mr. Gresham to come in to say, hey, I got mistreated too. I was passed over for promotions or I didn't get a raise. And I think it's because I was older or I was male or whatever discriminatory intent he thinks MARTA had. This isn't his case, it's your case.
And you told me if I say it, you'll object to it, and you'll object to it.
Well, I won't object. I will exclude it. But tell me what he's going to talk about your situation, because his situation. Let's say he honorably served MARTA for 100 years, and he got a gold watch and this and that. That's not your case. That's his situation.
He can talk about the criteria when it pertains to job promotion.
Okay.
Yeah.
So he's going to help educate the jurors from his
Criteria?
perspective on what it takes to get a promotion, et cetera.
Yes.
He's sort of your,
Oh my God, I'm sorry. We're going to learn something here. I've never even heard the word criteria before. I think there's going to be learning.
using this word unofficially, so don't jump out of your seat, Ms. Lewis. He's sort of your expert for the jury, for them to understand how promotions work and how you get evaluated. And he'll be looking at it through the union lens because he was or is a shop steward. Is that a fair summary?
Yes, and he'll be looking at it through and just an employee, been there 40 years.
Okay, all right. Ms. Lewis, assuming that is the main area that Mr. Gresham covers, that seems relevant. And he'd be subject to cross-examination in case you find his testimony to be inaccurate because he might not be the supervisor who would be, or the committee that would be making promotion decisions. But it sounds like he would be qualified to explain to jurors how that process works, given his history and connection with MARTA. Your thoughts about that, if that's what Mr. Gresham is limited to?
I will subject him to cross-examination, Your Honor.
Okay, and you will certainly be able to do that. I just want to avoid a scenario where you're objecting each question. If Mr. Pope stays in that turf and he establishes that Mr. Gresham has a basis to answer the questions, so they're not speculative, things like that, that strikes me as germane to this case and Mr. Pope's complaints. But I think it's important that we're previewing it so you know what's coming. You've had notice that Mr. Gresham was a potential witness and you explained you chose not to depose him. So I feel comfortable going forward that way. I just want to make sure you understand and are not wanting greater clarity before we dive into that.
Well, I don't want to waive any basis for objection with regards to him. I'll be very transparent.
You can't hear me?
He has absolutely no qualifications to speak to promotions as it relates to a journeyman ET, which is what is alleged in this amendment.
Okay, I hear you, and I'm not in asking you, we're going to be able to go forward with this. You waive nothing at all. I just want to avoid setting up, for example, if what Mr. Pope said is that Mr. Gresham is going to talk about my medical condition. You, I suspect right now would say, no, I object holistically to that area of testimony. I don't even want to cross-examine him because he will be providing hearsay, things outside his area of knowledge, etc. Which is why I asked Mr. Pope in advance. What Mr. Pope has described sounds like a space in which Mr. Gresham might be able to operate, subject to cross-examination. But I just didn't want you suddenly moving for a mistrial because Mr. Gresham said, hey, I've been with MARTA for 40 years. Here's my understanding of how X and Y works.
No, not mistrial basis, Your Honor. I just want to make the court aware that any testimony outside of real services, I think is fair game for objections because that's just not within his scope based on his experience.
We'll hear what he has to say about it and what you have to say about it. But it sounds like Mr. Gresham is a go.
Yes.
Obviously, you can testify. So we covered that. We covered Mr. Royal. Mr. Pope, was there anything else you wanted to go over before I bring the jurors in?
Oh, yes. I wanted to question her witness, Mr. Enos.
Yeah.
I want to call him to the stand as well.
You can call Mr. Ennis. He's here. So you're able to do that?
Okay.
Okay.
So why is not he ain't out there?
Well, we talked about that yesterday. If you had a lawyer, you would still be able to be in court even though you're going to testify because you are one of the parties. You are Christopher Pope. So obviously you're here. You're representing yourself. But if you had Sally Smith as your lawyer, she'd be sitting here and you'd be sitting here. And Ms. Lewis couldn't say, well, wait, Pope's going to testify. You're a party. Well, MARTA doesn't exist as a human. It's a corporate entity. It is allowed to appoint an agent, and that agent gets to stay in court for the entire trial as MARTA's representative. And they have designated Mr. Ennis as that person. So they've got a lawyer, just like you could have a lawyer. You're choosing not to have one. So it's lawyer plus party, and Mr. Ennis is that person. They could have selected someone else. It could have been the CEO of MARTA or the chairman of the board or this or that. But Mr. Ennis, it sounds like for good reason because of his knowledge and expertise. He's the agent because he can lean over to Ms. Lewis and say, this is what a journeyman 7 means. And she might not know that, but he can help educate her on that. And he may well testify, but you can call him as a witness.
Yes, sir.
Okay. Anything else from your side?
Oh, no, sir.
All right.
Thank you.
Ms. Lewis, anything from MARTA's side?
I think that curiously, Mr. Royal is not testifying, so we don't need to go through the documents that I reviewed last night.
Correct.
And they said obsolete, and, we've addressed the medical records, so I believe that's it.
All right. We received an email that I'll make part of the record. It will be Court's Exhibit 1 from juror number 1, meaning she was number 1 in the pool. She's also the first juror that you all ended up selecting. I'm going to read it, and then we need to talk about it. Dear Ms. Niles, thank you for the notice regarding my selection as a juror for the Pope versus MARTA case. I wanted to disclose that I have a personal connection to MARTA that may be relevant, but I wasn't 100% aware of how close until I ran into her on a jog this afternoon. Clearly, jury selection did not last long enough. She was out jogging. A close friend, comma, neighbor, comma, and client of mine, and then in parentheses is the name. It's Heather, and the last name is spelled L-U-Y-K. I don't know how you pronounce that. I'm going to say Luke. Heather Luke currently serves both the chief of staff and chief legal counsel at MARTA as program manager. While I am not personally connected to those individuals, I am closely connected to Heather, and I wanted to be transparent about this relationship in case it presents any concerns regarding impartiality. Please let me know if any additional information is needed. And she said, I'll be here unless otherwise notified. She sent this at 8:30 last night, so I didn't reach out to her. She's here. I'm gonna bring her out in a minute and ask her a few questions, thank her for this disclosure, and ask her a few questions about it on the record, and I'll give both sides a chance to ask her questions. I appreciate her disclosure. I don't think it is disqualifying. Just the fact that she is a friend and neighbor of Ms. Luke, but we'll need to see how she thinks that would affect her ability to hear this case, if it would affect her at all. You can be neighbors of people who are connected to a party in litigation and still have a very, very open mind. So that's my proposal. Mr. Pope, any objections to handling it that way, bringing juror 1 out, asking her a few questions about this email?
Oh, no, sir. No objection.
Okay. Ms. Lewis, you okay with that approach?
I have no objection.
Okay. Does this name Heather Luke or L-U-Y-K, does that ring a bell? You know who this person is? Okay. And she is a MARTA employee?
Yeah.
Okay. I just wonder, we could really short circuit it if you're like, she worked there 100 years ago, and
Oh, okay. No.
that's a real MARTA person. Okay, all right. If you could get juror 1, Ms. Richardson, please.
And Judge, I didn't do this before we bring them out and start. I'm gonna need a brief moment because this is not the case that I was here for.
Oh my gosh, what case were you here? Oh, were you here for Archer versus Roldos?
Yeah. What
Yeah.
happened?
It's number 2 to this. And so this went out. So did you all, you were wondering why magically there was a court reporter here? Yeah, nope.
I would love to be.
Yeah.
The courtroom is amazing.
Thank you.
But
No, you should take your time. I mean, feel free to shut down. They need to pay you for being here today because they.
You can stay, MARTA will pay you.
How about let's work with juror 1 and then you guys sort that out. Okay.
After this.
Good morning.
Good morning.
So this court reporter was here for a different trial. And she said, wait, you're talking about MARTA. I thought this was Archer Restoration. That's a case that is after this one. Thank you for your email. Ms. Niles forwarded that to me. I've talked about it with Mr. Pope and Ms. Lewis. And I want to ask you a few more questions, or a few questions about what you shared. Remind me your profession, because you, first of all, how do you pronounce this person's last name? Is it Luke? Like? Okay. Ms. Like, you mentioned was a client of yours, and I couldn't remember what that means. If that's like you're a chiropractor or you slice meat for her, or what is it you do? Interior design. So you make her house look nicer. Okay. And is that your connection? Is that it's professional, or you guys are also neighbors?
We're also neighbors. She was a roommate with my sister-in-law, so like I know her well. We don't like catch up about work. But when that run-in happened, I was like, that's significant. I should probably let them know.
Got it. When you say run-in, not like she accosted you and said, "Hey, you better do this during the." I know you're a MARTA juror.
They were.
You're jogging. You saw her, and the light bulb went off. Okay. Tell me how often you and Ms. Discuss her job as a program manager.
Rare.
Okay. What do you understand her job to be?
I didn't know her job title until yesterday, so I thought it was communications.
Was she wearing a badge that said program manager, or how did you learn her job title?
No. When we ran into each other, we were talking, and I told her that I was going to be here tomorrow, and I was like, oh wait, what is your scenario? What do you do at MARTA? And then she told me.
Okay.
And I was like, I didn't tell her the nature, but when I was telling her I was coming here tomorrow,
Okay.
it clicked for me.
And did she indicate that she knew anything about this litigation?
No.
Okay. And so really yesterday was the first time you knew what her job title was.
Yep.
But if you had bumped into her 3 days ago, you would know you work for MARTA. I think you do communications. Yep. Okay. And it sounds like your connection with her isn't professionally because you did interior design for her MARTA office, but it's professionally because you did things privately in her personal home. Okay, got it. Do you have any concerns, Ms. Richardson, that your relationship with Ms. would cause you to be anything other than neutral coming into this case? All right. Mr. Pope, do you have any questions for Ms. Richardson about her connection to Ms. or anything about her neutrality coming into this case?
No, sir.
Okay. Ms. Lewis, anything for Ms. Richardson? All right. Thank you again for the disclosure. It was the right thing to do. We'll get you all out here in a second. All right, we're going to go off the record for a moment, and why don't you guys talk business? Mystery court reporter and MARTA, do you have a card? Consider as some comment from me on the evidence, the strength of evidence, lack of evidence, or that I have any leaning whatsoever towards one side or the other. I'm neutral in this case, and my role is to make sure it is fairly tried and that the case is tried consistent with the laws of Georgia and the rules of evidence. That's the extent and impact and meaning of anything that I say during this trial. Your job is to figure out what are the facts of this case, what happened, and is what happened something that makes MARTA liable to Mr. Pope. In deciding that, you'll be considering the evidence, testimony, and exhibits.
Okay, we skipped it ahead a little bit while they were doing that. I don't know if you can hear me at all. And I think the idea here is that I got close to opening statements,
as well as the law that I give you at the end of the trial. In doing your job, you will necessarily be determining the credibility or believability of witnesses. It's for you to decide which witnesses you believe and which witnesses, if any, you don't believe. In determining credibility, you're free to consider all the facts and circumstances of this case, the manner in which the witness testified, what they looked like and how they acted while they were talking to you during this trial, the witness's interest or lack of interest in the case, and the means and opportunity a witness has for knowing the things about which he's testifying. You may believe or disbelieve all or any part of the testimony of a witness. While you're determining the facts of the case, you may find that there are conflicts in the evidence. If you do find conflicts, you should try to reconcile them as if every witness has been testifying truthfully to you about what he or she remembers about this case. Often one person will see things or recall things differently from someone else who was there at the same time. That doesn't mean one person's being truthful and someone isn't. It just means that recollections differ. If, however, you find that some parts of the evidence are in such conflict with others as to make it impossible for you to reconcile them, you should believe the evidence that seems most real. What is da 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 da, or give me an aerial photo of this situation. Writing them down on those note cards, you'll see there are a few stacks of note cards there. Please write legibly, only one side of the note card. You can write more than one question on the admitted is not asked. It just meant it wasn't the proper question. Doesn't mean that one side was scared of the question or that you're really onto something. It just means maybe the only way for that witness to answer that question would be hearsay. And that's not something we do here. You must decide this case solely on the testimony you receive and the exhibits that are admitted. Hey, you need to take that down, Mr. Pope.
Sorry about that. Oh,
Please don't share your screen until that's all right, but until you have successfully tendered an exhibit.
yes, sir.
All right. You all, jurors, decide this case only on the testimony and evidence presented here. No visits to a MARTA station if there's a MARTA station that keeps coming up during testimony. No outside research, as I mentioned. And again, to repeat, no early discussions about the strengths or weaknesses of the case for either side. You'll have all the time you need to deliberate in this case, but you don't start your deliberations until you've heard all the evidence, closing arguments, and I've given you the legal instructions. Once the case is over, you are, of course, free to do anything you want.
By the way, the jurors are currently deliberating
With the information that you gleaned. Your confidentiality is just during your deliberations. There's no prohibition when the trial is over to talk about it with other people. But between now and the time you're released from your service, it's important that you not interact with others about it. It will be very natural when you get home tonight to want to vent or say, hey, here's what happened today. But you need to be circumspect. Someone's going to say, honey, how was your day? And it would be, it's great spending time with Judge McBurney. That's it. Don't go beyond that. You can get real about how bad it is when the trial is over, but well-meaning and accurate about what happened in court. But stay away from that. And with that, I am done with my preliminary instructions to you all. And I will turn to Mr. Pope to ask him if he wants to give an opening statement.
Yes, sir.
All right. When you're ready, you can address the jury.
Good morning, Your Honor, opposing counsel, and ladies and gentlemen of the jury. May it please the court. My name is Christopher Pope, and I am here today representing myself in this matter as a pro se plaintiff. This case is about my employer's violation of my civil rights, labor rights, and my dignity as an employee. I was showed through evidence and testimony that my employer has engaged in the following illegal actions: discriminated against me on the basis of age, gender, and denied me promotions I was qualified for, retaliated against me for filing an equal employment opportunity complaint. I asked the court and the jury to consider the totality of the circumstances and apply the laws Congress enacted to protect workers like me and you. Justice demands accountability, and I am here to ensure that the truth is heard.
Thank you, Mr. Pope.
Yes, sir.
Ms. Lewis, are you going to give an opening statement at this time?
Briefly, Mayor. Good morning, ladies and gentlemen of the jury. Again, my name is Karima Lewis, and I do represent MARTA in this employment discrimination action. I want to thank you again for your service here today, and respect your time. I'm going to jump right into what the case is about. This is an employment discrimination case by a disgruntled employee who is still an valuable employee of MARTA. He began his employment with MARTA in 2012 as a bus operator, and was subsequently promoted to rail operation in 2014. I believe the evidence will show that as a rail operator, the essential duties include safely operating the MARTA passenger trains. And you would do that to pick up passengers and to discharge passengers at the rail station platforms. They're also charged with making clear and concise transit announcements at each rail station. This is one of our most safety sensitive positions, of course, because we're transporting our most valuable asset, which are our patrons. There are a number of safety policies that apply to these positions, which include how many breaks a rail operator can take and when precisely they can take that break. It's because what I believe the evidence will show, time is of the essence with regards to transporting patrons. So a lot of policies and restrictions apply to these different rail operator positions. During Mr. Pope's employment with MARTA, he has violated several of these safety initiatives and policies. Because of that, he has been disciplined. Some of those violations, as you will hear in evidence, include occurrences. Occurrences will be defined as no-shows to work or tardiness to work. He has been disciplined for failure to follow instructions. Of course, in these positions, when transporting patrons amongst the MARTA rail lines, following instructions is very key. Lastly, he has been disciplined for conduct unbecoming of an employee, and that is for name calling, conduct that is not conducive to a safe and healthy work environment. Because of these disciplinary actions, Mr. Pope has taken it personally and has asserted that the results of these disciplinary actions constitute discrimination. What I believe the evidence will show is that MARTA has made every single employment decision with regards to Mr. Pope according to policy and according to the safety mandates, not only under federal law, but under state law, the state law of Georgia. You will hear from Mr. Ennis, Mr. Garrick Ennis, who is a rail superintendent who has the supervisory and official authority to make final calls with regards to discipline of rail operators. And he will discuss with you the procedures by which Mr. Pope was either written up or sanctioned for his conduct. At the conclusion of this case, I am confident that you will find there were no adverse employment actions that constituted sex, age, or retaliation against Mr. Pope. Thank you.
Thank you, Ms. Lewis. Mr. Pope, you can call your first witness.
Yes, sir. I would like to call the defendant witness, Mr. Garrett Ennis.
Mr. Ennis, if you would take the stand, please.
Seriously? We need sunglasses in court?
First, we ready right now. You swear affirm that testimony will be able to be the truth, the whole truth, and nothing but the truth, so help you God. Yes. You don't even have a seat.
Big Dummy's got a nice
Can you
suit on. I'll
say
give him
your
that.
name for the record?
He does.
Garrick A. Ennis, Garickennis.
May I proceed?
Yes, sir.
Yes, sir. All right. Mr. Ennis, are you gainfully employed at this time? If so, what's the name of your current employer?
MARTA.
How long have you been employed by MARTA?
Since August 27, 2012.
Mr. Ennis, can you speak up a little bit, please? The
20.
chair doesn't have wheels, so you may need to lean in. You can also scooch it, but it's a heavy chair. We don't want people rolling off that little
Yes, sir.
dais.
And that would be August 27, 2012.
Yes, sir. What is your current position title?
Zone Superintendent, Rail Services.
Can you speak up? Say it again.
Zone Superintendent, Rail Services.
Yes, sir. And how long have you been a rail zone superintendent?
I think I was promoted to that position in 2021.
You said about 4 years.
Yes, sir.
What was your previous position prior to being promoted to rail zone superintendent?
Rail Superintendent.
Prior to being a rail superintendent, what was your title?
Rail Supervisor, Tower Supervisor.
Prior to being a tower supervisor, what was your position?
Rail Operator.
Does that mean you drove trains?
Yes, sir.
Yeah.
Came
for
through
the-
the ranks.
Yes, for the record, I drive trains. Mr. Ennis, during your time as a rail superintendent, rail supervisor, have you ever sat in on I'm trying to get my words together. Hey, have you ever sat in on a employment when an employee is just, giving an interview for a job?
Yes.
Could you name some of the criteria that employee must have to be promoted?
For one, you have to have the qualifications. And in reference to that, we look at your attendance records, occurrence records, and discipline.
Yes, sir. Is there a certain amount of occurrences an employee has to have before they're not considered for a position?
What do you mean by occurrences?
Occurrences is like when you call off,
Like you miss a day of work? or
yes,
okay.
yes, occurrence. So, back to my question, is there a certain number of occurrences that the employee can have before they're not considered the opportunity to be promoted for a job?
Okay, so to be promoted, you first have to apply for the job.
Yes, sir.
And it depends on the job you apply for, 3 occurrences. And it has a scale that they go through and eliminate or recommend the next person to move to the next level.
Okay, for the work, you said 3 occurrences?
3 occurrences.
Yes, sir. No further questions from the defendant.
Okay. Ms. Lewis, do you have any questions for Mr. Ennis at this time?
No, as long as I can call him in my case in chief.
You sure can.
Okay. No
All right,
question.
Mr. Ennis, thank you. You are free to step down. Mr. Pope, who's your next witness?
My next witness is Ronnie Gresham. I'd like
Okay,
to call Mr. Gresham.
okay. Deputy Gordon, do you mind getting Mr. Gresham? Thank you.
I see. Can you state and spell your name for the record? For my name? Yes.
You can take a seat first. Why don't you get comfortable, make sure you're near the microphone, and then if you would state your first and last name, spelling both.
Okay, R-N-Y, Gresham, Gresham.
When you're ready, Mr. Pope.
Oh, yes, sir. Good morning, Mr. Gresham.
Oh my God. What is this sweatshirt? And how did he think that was appropriate to go to court? Is this a world's best dad shirt or something or something like that? This is good.
Mr. Gresham, are you currently employed? If so, please state the name of your current employer.
Current employee, I'm retired.
Mr. Gresham, what company did you retire from?
MARTA,
When did you retire, Mr. Gresham?
February the 1st, 2024.
How many years of service did you have with the authority, Mr. Gresham?
39 years.
What was your title at the time of your retirement, Mr. Gresham?
Rail operator.
How long was you a rail operator, Mr. Gresham?
33 years.
33 years. Mr. Gresham, could you, no, that's the wrong question. When employees want positions and they apply for the positions at MARTA, would you agree or disagree MARTA management based the promotion offer their attendance?
Really based on attendance. You know what? They don't.
I tell you what, let me ask you again, please.
Okay.
When employees apply for positions at MARTA, would you agree or disagree that MARTA management base the employees, their attendance, before they're able to proceed in promotion?
No, they don't. They do not.
Would you agree or disagree that attendance at MARTA plays a important role in moving up?
It used to, but not anymore.
When did it change?
It changed when they started bringing people from off the street and people from states and stuff like that start changing. Mhm.
But was that, you were there for a long time. Was that in the 80s, the 90s?
It really started when Simon Eddy, whatever year that was, I think it was in the early 2000 when Simon Eddy started changing a lot of stuff. He was the CEO at the time.
Okay.
Mhm.
Wait, I got one more question. Mr. Gresham, if an employee has a accumulator of occurrences on their record, meaning a lot of occurrences, will that affect the employee from being promoted?
Negative. It would not. You know, they'll accept anybody, to tell you the truth, regardless of how their records are.
No further question, Your Honor.
Okay. Ms. Lewis, do you have any questions for Mr. Gresham? All right. Mr. Pope, can Mr. Gresham be excused?
Oh, yes, he can.
Mr. Gresham, thank you so much for being here. You are free to go. Appreciate it. You good? Okay. Mr. Pope, next witness?
No witness. I'd like to enter my exhibits into evidence.
Okay.
Yes.
When you say exhibits, I need to see them. More importantly, Ms. Lewis needs to know which exhibits you're talking about.
Exhibit 50.
That's one, just 50?
Yes.
Okay.
Exhibit 50.
Do you have exhibit 50, Ms. Lewis? Okay. If you could share it with Ms. Lewis.
Oh, okay. Yes. I can also
I don't have that exhibit.
Let me take a look. I have a copy of the exhibit list. Is it the same 50?
yes, sir. I can come show you as well if you need to.
It's okay. It is referred to as a conference record.
It is exhibit 50 is a labor agreement, MARTA and Amalgamated Transit Union 732.
Okay, so that's a different 5. Do you have a different witness list now? You submitted a witness list. You filed one with the clerk, and it's got a 50, and that's listed as some kind of conference record. I don't know what that is, but that's not that thing.
No, sir. I can.
It's a different one.
Oh, no, sir. This is exhibit 50.
Okay, you can put it down. Don't publish it yet. Ms. Lewis, is exhibit 50 anything that either you already had or was provided in discovery?
It was not provided by Mr. Pope in discovery.
Okay.
It is a very close-up picture of an excerpt from the transit union agreement.
Okay. Is the transit union agreement something you're familiar with?
Not that portion, Your Honor.
Okay.
I don't know, it doesn't have a page number or any type of citation to where I can reference it.
Okay. Mr. Pope, do you have other exhibits that you want to admit?
Yes, but the page number for that exhibit that I'm referring to, I have the MARTA booklet, and that page is in this book right here.
Oh, that's where you got it, was from the book you're holding?
Yes, sir. This is up to date 2025 version. This what I'm trying to get, into exhibit and evidence is in this book right here.
Okay. Are there other exhibits that you are wanting to admit right now?
Well, after I admit this, yes.
Okay, so I'm just map out for me where you're going, because we may take our morning break so that we can talk about this outside the presence of the jury.
Okay.
I can't rule on 50 right now. I think we need to talk about it some, but if there are others, then Ms. Lewis will know they're coming. We maybe can talk about them all together, but just tell me what you're going to admit. Some exhibits. Do you have other witnesses?
No, sir.
Are you going to testify?
Yes.
Okay, so you do have another witness. You'll be testifying.
Yes.
Okay. you want to get these exhibits admitted before you testify?
Yes.
Okay, then, ladies and gentlemen, we're going to take our morning break a little earlier than I thought we would, but I'm going to spend some time with the parties talking about these exhibits. And it sounds like when you come back in, Mr. Pope will be testifying, and there may be some exhibits that come in. Don't talk about the case while you are, you know what? I forgot to ask you all if you had any questions for Ennis and Gresham after I promised that would happen. My bad, it was sudden. So we'll see how that plays out. I promise if Mr. Pope testifies, I'll ask you guys that. But anyway, during the break, don't talk about the case. Anything in the refrigerator and in that white basket is for you all. You can bring water out here unless you have to have food because of health reasons. Don't bring food out here, but you can bring water out here. We'll get you back out here as soon as we work through what we need to. Thank you.
All right, Durham.
Any chance Mr. Gresham, is Mr. Gresham sticking around? Or do you think he got out of here?
Oh, he's probably sticking around.
See if he's out there. If he is, after the break, we're going to get him back on the stand because the juror had a question for Mr. Gresham. So here's what I need you to do, Mr. Pope. If there are exhibits that you want to admit, I need you to identify them now. He's still here. Can you ask him to stick around? Thanks. It'll only be like 10 minutes, but he does need to stay. If you'd make a stack of those exhibits so Ms. Lewis knows what they are, and then we can talk about how they might be admitted. So that way we don't have to send the jury out each time. And I guess you should be thinking about the ones you want in, because you're the next witness for your side. Is that correct?
Yes.
Okay.
Yeah, she want to question me about the evidence, so I guess if that's what it's for, me being a witness, I go up there and talk about this.
So if there's any more testimony you want the jurors to hear, it sounds like it will come from you because you called Mr. Ennis, you called Mr. Gresham. And so if you want to testify about what you experienced,
Oh, yeah.
you have to take the stand.
Yes,
You'll be
sir.
sworn in, and then no one's going to be asking you questions initially. You'll be basically narrating. My name is Christopher Pope. I work at MARTA, whatever it is you want to say, but you're just talking with the jury. If there are exhibits that you want to use while you're testifying, those need to be admitted.
Okay.
But you need to make a stack of the ones that you're going to try to admit so Ms. Lewis can look at them and let me know if she has any objections to their admission.
Yes, sir.
Okay? So we're going to take maybe 5 minutes while you make that stack. When we come back, we'll talk about them. Okay?
Sir.
Thank you.
Thank you.
Oh, and to repeat, actually what we'll do first when we bring the jurors back is get Mr. Gresham back on the stand so that I can ask, let me tell you what their question was. Was Mr. Gresham ever a supervisor or only a rail operator? I think that's a legitimate question. I'll ask it, he'll answer. And if either of you has follow-up, you can ask Mr. Gresham about that. Okay? But we'll be on break for 5 minutes. I'll come back. We'll go over those exhibits.
Both on.
Both?
Yeah, both.
Okay. All right. What's the exhibit designation?
Exhibit A.
A? All right, there's no objection to
No
A.
objection to A.
All right, A is okay.
Exhibit B.
B? Okay, we're on a roll here.
Exhibit S10.
S10, no objection.
Exhibit 36.
36,
It's the second page to 36, but it's labeled 36A.
so 36A, no objection.
Right, they're the same document, just page 1 and 2.
Well, why don't you, it's just a 2-page document?
It is, but they're both labeled with exhibit numbers.
Okay, can we just staple it and it's exhibit 36? You okay with that, Mr. Pope?
Yes, sir.
Okay, I got a stapler that Deputy Gordon give you. So 36 is okay.
36B.
36B,
Yes, sir.
okay.
Thank you.
Thanks.
36C, no objection. I need the stapler again. It's the same thing, sorry.
It's all right. It's good for him to get steps. Why don't you hold on to that till we're done with this process?
I think there's a 2.8, S28. Same, it's a mistake. Second. And 1Z6.
One, can you show that to Mr. Pope? What are you calling that?
Exhibit 1Z6.
One, okay, 1Z, the letter 6, all right, 1Z6. So the ones you described, A, B, S10, 36,
1 second. A, B, okay.
A, B,
Mhm.
S10,
Mhm.
36,
30, it says 36. Oh, yes, okay, sorry, yes. Mhm.
36B,
Mhm.
36C,
Mhm.
S28,
Mhm.
and 1Z6.
Those are the ones I have no objection to.
Okay, can I treat them as admitted now so Mr. Pope can go ahead and use them during his testimony?
Sure, Your Honor.
All right, Mr. Pope, those exhibits are admitted. You don't need to, I mean, you can talk about them, et cetera, but you won't need to say, Judge, I tender X. Those are in. If you want to share them on the screen when you're testifying, you can do that, but there's some with some concerns. And what are those?
Okay,
I need the numbers.
this is exhibit 1Z4. I'm not sure exactly where this is from, Your Honor. I'm not familiar with this document at all.
You're talking about 1Z4?
1Z4, or I'm sorry. Is this I or 1?
1Z4.
1Z4.
Okay.
Looks like
So let's not talk about what it is yet. I just want the universe of
number.
not okay. So 1Z4, does that need to be stapled because it's a bunch of pages?
Yeah.
Okay, let's do that.
S11 is next. Exhibit D,
So 1Z4 and D?
S11.
Oh, S11, I missed that. Okay, S11, D as in Delta.
That's correct. Exhibit D is in Delta.
Okay,
Exhibit C is in cat.
okay,
And exhibit 50,
50.
50.
All right, so there are 5 exhibits with which you have concerns. All right, and is your concern that you've not seen them before or they weren't disclosed?
But as well as authentication.
Okay, Mr. Pope, why don't you come on up and let me know if you disclosed, and if so, when any of those 5, because I don't need to worry about authentication if they were not ever disclosed, sort of like the medical records. Okay, so 1, you may never have received them. 2, how does he authenticate? And then 3, how are they
It's
relevant?
good.
Okay,
It's really good. I'm impressed.
we'll get to it. If it's not something Mr. Pope
Totally
produced,
appropriate.
then that ends the discussion. So,
Exhibit D was produced.
oh, D was produced.
My objection to that is no.
Okay, let's start with D. Tell me what
Yes,
D is,
right
Mr.
here.
Pope, and how it's relevant to your case.
D is relevant to my case.
First, what is it?
It's a, grievance.
A grievance.
Yeah, grievance response.
Grievance response?
Yeah, I filed a grievance.
And this is MARTA's response to your grievance?
This is MARTA after they've done the investigation. This
Okay.
is their response.
And is this a grievance that is in the complaint?
This
Because
is the grievance that is in the complaint.
which one?
These, let me see, hold on a second.
The date for this grievance is December 7th, 2023.
Okay, I thought, okay, let me look. Now that I've got your complaint in here. So your complaint, where's the December 7th, 2023, or where in the complaint do you talk about what the grievance is about?
Number 8 is, September 23.
When you were suspended for
That's-
3 days?
Yes.
And this grievance relates to that?
Yes, you file a grievance and, you wait on the investigation and you.
Okay. Ms. Lewis, do you agree that D relates to the September 23 suspension?
One second. I'm sorry that I'm hesitating, but I only provided one page of the grievance, so I can't,
D is only a one-page exhibit?
it's 3 copies of one of the first, I think of the first page of the grievance.
Okay,
Which I think lacks the substantive nature of, what it was about, but he does state there were absences from August of 2023 that he's been testing with regards to what I had.
okay.
Um,
It relates to an attendance form, et cetera. Any reason why D is just one page of MARTA's response?
Sir, I have 2 pages. If you don't mind, can I ask her what dates she's reading it from her computer that she received it?
She's not, she's holding it in her hand.
It's just the first page of the grievance.
Yes, right here.
But he's got a second page attached. I just want to find out if the grievance is related to paragraph 8. If it is, you can use it. Can you give her, please, the
Okay.
D?
Oh, no problem, sir.
Give her the D.
Your Honor, I don't think that this is related. The conclusion of this grievance removed 4 occurrences off of his record, 8/1, 8/12, 8/21, and 8/22. I don't think that those are the basis of paragraph 8, this is September 2023 suspension. That had to do with,
A refusal to sign an attendance form.
so
So how is paragraph 8, Mr. Pope, related to the grievance?
Paragraph 8 is an incident that I was suspended.
Yep,
Thanks to that grievance. I was suspended for 3 days for failure to sign,
an attendance form.
inaccurate attendance form,
Okay.
which is that grievance. I filed a grievance on the issue.
Oh, meaning that the attendance form was inaccurate?
I filed a grievance on the whole scenario, the 2023 coming into the office, getting suspended for no reason. I mean, for failure to sign attendance.
Okay.
That was inaccurate. So I filed a grievance on that issue.
Okay.
It takes 2 or 3 weeks for the grievance to investigate.
And what you're going to testify to is that D is MARTA's response to your grievance?
Yeah, the
Okay.
response to the unjust discipline that they did on 2023.
Okay.
he grieved several FMLA related occurrences that were improper. It had nothing to do with you arriving to work and refusing to sign your tardy split late. This is with regards to disputing occurrences related to FMLA.
Objection, Your Honor.
So you don't need to object in this
Okay.
context. Just let her finish and then I'll hear from you.
Okay.
Dates that were made have nothing to do with what's alleged in the amended complaint. And I think that this would confuse, as it's confusing us, it would confuse the jury and conflate
It's not time to object, dummy.
issues that don't need to be conflated. What's alleged is that he was unjustly suspended for refusing to sign his attendance record on September 21, 2023. Now, these are August FMLA days that were forgiven.
Right, but what I'm hearing Mr. Pope say is they're all connected. It was, the attendance form showed incorrectly in his mind that he missed days. And so he grieved that, and MARTA ultimately said, oh yeah, look at that. Those were valid FMLA days. They shouldn't have shown up as tardies or missed days. Is that a fair summary, Mr. Pope?
Yes, sir.
Okay, I'm not saying that's actually what happened, but that's his take on it. And that's, so I'm gonna allow D in. I don't want us to take up a whole lot more time. D is something that you did produce, it sounds like. But these others, let's start with C. Let's stick with the alphabet. What is C?
C is the administrative hold that they, I'm not gonna show it to you. Administrative hold that they put me on it.
It's okay to show me. You can't show the jury. It's not gonna mean anything to me. Just say what it is.
Oh, okay, this is what the superintendents give, when they want to put you on hold,
We'll put you on hold like you're on the phone and they make you wait, or hold, what do you mean by hold?
like, well, suspend you.
Okay.
Yeah.
And that's a hold that you received from a supervisor
Yes.
in connection with which paragraph?
Let me see.
What was your question, Herbert? Sorry.
So Mr. Pope has explained to me that C, Charlie, is basically a suspension notice that he got. He called it a hold. And I'm asking him if it relates to one of the paragraphs in the complaint. Then to me, it's relevant. I know you hadn't seen it before, but it's a MARTA document. And so I'm inclined to let that in if it's a hold he received in connection with one of these paragraphs and not something that happened before or after the chronology of his complaint.
Okay, you can exclude this.
Okay, C will stay out. How about 50, 50? What is that?
0. 50 is a labor agreement, Marvin's labor agreement.
Oh, this is the excerpt from that book?
Yes,
Okay, let's take a step back. That book, that spiral bound book that Mr. Pope held up when the jury was in here, is that a document with which you're familiar, Ms. Lewis? I don't mean you've read it or you've memorized it, but is that like a MARTA document?
The book?
Yeah.
I don't.
It sounded like it's a,
We do have a labor agreement, Your Honor. This is says July 23rd through December 31st, 2025. They typically do print it in a book. I'm not familiar with this particular one.
okay, but that might be something that the union hands out to all the employees, so they've got a copy of the labor agreement. Mr. Ennis is nodding his head, so he's not being thrown a loop by hearing about that. And it sounds like, so let me finish. That Exhibit 50 is an excerpt from that. Is that correct?
Yes,
Where in that, but what page in that book did it come from?
66.
Page 66? Okay. Ms. Lewis, are you or Mr. Ennis able to call up the labor agreement on the screen so you can, not for me, but are you able, if you want to put your hands on the labor agreement, can you do that, or is, okay. All right. So it sounds like page, go ahead.
Sir, let me make sure 66.
Good, you make sure. But it sounds like plaintiff's exhibit 50 is an enlarged version of a page from the labor agreement, which I'm inclined to let in. But you are certainly entitled, Ms. Lewis, to know what page so you can provide greater context either on cross-examination or through Mr. Ennis.
Page 21.
Page 21.
Yes.
Okay. So exhibit 50, is it all of page 21 or part of page 21?
Well, in the book is all, but this particular document I have is a more like a B. It's letter B. It's talking about seniority.
Okay. Can you just hand to Ms. Lewis 50 and page 21, just so she can see, yep, I get it. That's where it came from, because Mr. Ennis is going to be looking that stuff up. All right, Ms. Lewis, is that accurate that plaintiff's exhibit 50 is some part of page 21 from the labor agreement? Okay, I want you to make your record. I'm inclined to let that come in as well. Do you have any objection to that now that you know what it is?
Yes.
What's your objection?
Relevance, and it was not disclosed in discovery. This is my first time seeing that exhibit today.
Okay, I'm going to allow it in since it's part of a labor agreement that MARTA has entered with the union, but your objections are noted. So D and 50 have been added to the OK column. How about 1Z4? What is 1Z4? Mr. Pope?
1Z4 is a document showing that I applied for ET rail car maintenance journeyman position.
So it's an application you filled out?
Yes, it's application field, and it's showing the date that I applied on.
And what was the date you applied?
January 17th, 2024.
January 17th, 2024. All right. That seems to fall outside the timeline of your complaint. Do you agree with that?
Oh, hold on a second. You say it fall off the timeline?
Well, your complaint talks about incidents in 23 and 22. So if you applied for something in 24, that seems like it's outside the scope of your complaint. And remember, we discussed yesterday, you're not going to be permitted to share with the jury. Let me tell you some other things MARTA did that are outside the time frame of your complaint. And so if you applied in January of 24 and were denied that promotion or lateral or whatever it would be, that's not part of your complaint. That may be something new that you bring against MARTA, but that's not this case. Does that make sense?
Yes, it makes sense. But
Okay.
however, number 3 of my complaint speaks about MARTA overlooking me discrimination, me being passed over for journeyman ET maintenance.
Oh, and is that that's the application?
Yes,
How many times did you apply for journeyman ET radio maintenance?
I applied once.
One, and that's the only time you applied?
Yes.
Oh, okay. I didn't realize there's no date for that paragraph, but that is there. And it is your amended complaint, which did come later on. So then I understand the relevance. Ms. Lewis is saying she's never seen that before. That application you would have submitted to MARTA, or it goes through a outside hiring agency?
Oh, no, it's submitted to MARTA.
Okay.
Yes.
And when did you provide 1Z4 to Ms. Lewis?
Well, okay. I mean, I may be wrong, but outstanding trial management order
Mhm.
that was revised 14th January 2025. The exhibits and exhibit list it's the deadline was before jury selection.
Mhm.
Or am I
Is it on your exhibit list?
exhibit list? Yes.
Okay. That one just has numbers. It doesn't have a 1Z. What would it be on your exhibit list? Do you remember? You had 103 things listed.
Okay, exhibit list. I gotta pull it up for you.
Tell me what it's called. I may be able to find it. What's this thing called?
Again, I gotta pull it up,
No, but 1Z4, what is that document called?
it's job application. I forgot what I named it on my exhibit list.
Okay.
So I can
Yes, it wasn't called application. Let's see. Job. That's not there. Okay. Ms. Lewis, as you were preparing for this case several times and looking through, I think you referred to a document that's sort of like the personnel file for Mr. Pope. Would something like that not have been in there?
I don't know where you got that from. That's not in there. There's nothing like a document MARTA would produce in regards to a job application.
Okay.
I'm not sure where you got that.
Where'd that come from, Mr. Pope?
Well, when I apply for the job, I take a picture of the job I applied for, and when they denied the
Does 1Z4 have the denial in there, or it's just your application?
the 1Z4 has the what I applied for, and 1Z5 is showing you that this particular document is me, individual, as you can. Well, you don't see it right. Are you looking at it right now?
No,
I'm sorry.
I don't have it.
I'm sorry, but at the bottom of the document, it shows that when I was a part-time bus operator, offer being accepted to me. So this document is relevant, and the exhibits that you have already admitted, which she looked at and confirmed, this is the document showing that was stating that I was denied for the position.
That's the 1Z6?
Yes, it's the one that the guys already admitted.
Well, I'll tell you what, 1Z6 is in, and that'll be proof that you applied because you were denied that position. I'm not going to allow 1Z4 in because it sounds like it wasn't produced. And that gets us to the last one we need to talk about before we bring the jurors back in, and that's S11. What is S11?
Yes, sir. S11 is a part of, again, my amendment.
By the way, this guy sucks at this because he's pro se, but he's better than average. He beats the hell out of any sovereign citizen and is better than your average pro se. What he's doing is heading towards a point. It's not nearly enough to get it done, in my opinion, but it's not the worst I've ever seen.
The complaint,
Well, first, what is S11?
S11 is a email from the superintendent that's in my amended complaint by the name of Kenneth Jackson. That will be number. One second.
I see. It's paragraph 9.
Yes, sir.
Page 5.
Yes, sir.
So it's an email from Mr. Jackson. Is it the one that he sent to 49 employees?
Yes, not correct. Well, yes, employees, but may I add, management employees, not.
But it's specifically the email that you reference in paragraph 9.
Yes, sir.
Okay, seems relevant. Have you seen it before today, Ms. Lewis? Okay. Is the contents of the email something particularly problematic that you can't prepare for, Ms. Lewis? I appreciate you haven't seen it before. I just don't know what it says, other than that you would have known, assuming it's consistent with what's in the complaint, what was in that email.
Okay, I get what you're saying. The contents,
How long is the email?
it's not in a paragraph. It merely states that he's not to be allowed on the property during the suspension.
Okay.
I can't tell who it's sent to. My concern is it wasn't provided and it's not printed in a format where I can easily authenticate it or say that it was not altered or tampered or, mismanaged in some way. It looks like it's a picture of, I don't know, something.
Okay, but I think that'll go to the weight of that evidence. I'm going to allow S11 in. And so let me recap on the record, and then when the jurors are in here, I'll let them know. I find that A, B, D, S10, S11, S28, 36, 36B, 36C, 50, and 1Z6 can all be admitted. And Mr. Pope can tender them and publish them during his testimony. 1Z4, S11, and C, 1Z4 and C are not admitted. 1Z4 and C, do not try to tender them. Don't put them up on the screen. But all the others, you should have a pile of okay, and then the others, put them somewhere else.
Yes, sir.
Okay. And Ms. Lewis, those are admitted over your objections. Some of them were relevance, sufficient foundation, or late production, which isn't so much an evidentiary objection as it is the rules of discovery. So you preserve that for those records. Okay.
My concern is there are some I don't have copies of. For example, in Exhibit D, I have the first page, I don't have the second. Is there a way I can get copies of the ones I don't have?
At some point, yes. I don't want to extend this break any longer. And so if you can, Mr. Pope, if you would please give Ms. Lewis that stack of exhibits that are coming in. Ms. Lewis, if you'll go through those and figure out which ones you need copies of, I'll get copies made. So you've got a set. And then the originals will be what go back with the jury, if any of those go back with the jury, but they'll certainly be made part of the record. Okay. So if you could right now, Mr. Pope, give Ms. Lewis that stack of the exhibits I rattled off that are in, and she's going to make a note as to which ones she needs copies of.
Yes, sir.
All right. And if you could bring Mr. Gresham back in, we're going to start with him on the stand.
I want to say I know I have issues, but I have good intentions.
Hey, Mr. Gresham, thank you for sticking around. I skipped one part of your testimony, so if you'll take the stand again, we're going to bring the jurors in. I think probably one or two more questions.
I was under the impression that you wanted me to leave, period.
And so I didn't want you to do anything other than you were excused. So if you wanted to go, you were free to go. But I was mistaken, because what I said was truly, if you want to go home, you should go home. But then someone pointed out that I missed something. And so I'm glad you stuck around. But when we're done this time, you do not need to stay in the building any longer, but you're welcome to. You can even stay in court if you want. If you want to watch more of the trial, you're free to do that. You do whatever you're most comfortable with. Okay? Mr. Pope, have you given Ms. Lewis those exhibits?
Yes, I'm doing it. About 30 seconds, I'm ready.
Pardon me?
About 30 seconds, I'm just writing them down.
Okay. All right, Mr. Pope, are you ready for the jury to come back in?
Yes, sir.
You'll get those back. She's just going to note which one she needs copies of. Ms. Lewis, are you ready for the jury?
Yes, sir.
All right, let's bring the jurors in, please. Did you take a break when we first, Ms. New, did you take a break when we first took the break? Good, okay.
All right, the jury. Okay.
All right, everyone else can take a seat. Ladies and gentlemen, thank you for your patience. 3 quick things. 1, there are no assigned seats, so I encourage you to rotate around. Literally, you'll get a different perspective on what's going on in court, unless one of your colleagues needs to end because he or she needs to stand up periodically. So don't grab a seat and say it's always yours. 2, come on in and sit down. You don't need to stand. We stand for you. You're welcome when you do get in to take a seat. 3, I neglected to inquire whether you all had questions of either of the.
He was extremely lenient with him, as judges often are with pro ses. But the stuff he was letting in are things like agreements that they have in their possession and that kind of stuff. It wouldn't work for me or a licensed attorney, but they'll do that kind of. They'll make those liens for pro ses every time.
The first 2 witnesses, they went a little more quickly than I had expected and just hadn't gotten into my groove yet. So I've called Mr. Gresham back to the stand. He remains under oath, and we're going to pick up with his testimony. Mr. Gresham, I have a question for you. But before we do that, let me adjust one thing. Okay, Mr. Gresham, were you ever a supervisor for MARTA?
Negative.
Okay, you were always a rail operator?
Rail operator, yard operator.
Okay, is one of those positions more senior than the other or get paid more? A rail operator versus a yard operator?
Same pay.
Same pay?
It is special to be a daddy. That's all I'm saying.
Rail operator means you drive a train.
Rail operator means you drive a train. And in other words, rail operator has, if he's on the extra board, he has, if a yard job is open, he has to do that work.
Okay, what does a yard operator
The
do?
yard operator is putting trains together.
Okay,
Let's see what else.
getting the train ready to go, and then the rail operator hops in and goes off to Sandy Springs
Either to the airport.
or airport or wherever.
Yeah, that's
Indian
the
Creek.
duty of a yard operator. He's always putting cars into the shop and taking cars out of the shop because mechanics are not allowed to operate the train.
Okay.
We have to operate it to see if the train is functional.
Okay.
When they're working on it.
Got it. And your 2 jobs you had at MARTA were rail operator and yard operator.
And my younger years, it was a bus operator,
A bus operator, okay, but not a supervisor.
never a supervisor,
Okay,
because they wouldn't allow me to be one.
okay. Mr. Pope, do you have any questions for Mr. Gresham based on the exchange he and I just had?
Oh, no, sir.
Okay, Ms. Lewis? All right, Mr. Gresham, now you're really done. Thank you for coming back. I appreciate it. You're welcome to stay here in court. You're welcome to leave the courthouse.
Okay.
Okay,
All right.
thank you so much. Oh, because I hadn't asked, some people, take a seat, Mr. Gresham. Hold on one sec. Mr. Gresham, come right back. I'm sorry. I thought all the questions for Mr. Gresham had been written down, but I didn't ask. Some folks had done that. Does anyone else have questions for Mr. Gresham? It's not usually this chaotic. I manage it better. Hold on one second. Okay. Mr. Gresham, couple more questions. Can you tell the jurors how you know Mr. Pope?
I know Ms. Poe as a coworker, only as a coworker.
Were you ever involved in making any decisions as to whether Mr. Pope should get a promotion? Nope.
Nope.
Okay. And it sounds like because you were never a supervisor, you would never have been Mr. Pope's supervisor.
Mhm.
Nope.
No.
Okay. All right. Any other juror questions for Mr. Gresham? Mr. Pope, any questions for Mr. Gresham based on my additional exchange with Mr. Gresham?
Oh, no, sir.
Okay, Ms. Lewis? All right. So you can take, you're free to leave the stand. I promise I won't drag you back up here again, okay? Thank you, sir. Appreciate your time. All right, Mr. Pope, who is your next witness?
Myself?
Okay. Ladies and gentlemen, during your break, I ruled that the following exhibits have been admitted. And if Mr. Pope or Ms. Lewis want to publish them, make them viewable by you all, they are free to do that. A, and these are plaintiff's exhibits. So Mr. Pope's exhibits, A, B, D, as in Delta, 36, 36B, 36C, 50, S10, S11, S28, and 1Z6. Those are all in evidence. And if it's appropriate for them to go back during your deliberations, you'll have those documents. And Mr. Pope, you're free to publish them during your testimony if that's what you want to do. But what I need you to do is come on up here to be sworn in by Deputy Gordon. You may want to bring your laptop if you're going to publish exhibits while you're testifying. But come on up, bring your laptop or the exhibits, however you want to do that. Does he have them back?
I have the copy, the stack of the ones I needed copies of.
Okay, if you could send an email to me listing the ones you need copies of, the numbers. Yep. And then during a break, we'll make sure you get copies.
One quick second.
Thanks.
All right, Mr. Pope, come on up with whatever you need while you're testifying.
Oh, this should be fun. This should be fun. All right, I'm going to take it back to regular speed. Although sped up wasn't bad.
All right, put that down, but stay standing so you can be sworn in by Deputy Gordon.
Yes, sir.
Raise your hand. You swear affirm that the testimony you'll give will be the truth, the whole truth, nothing but the truth, so you God. Yes, I do. You know you have a seat. If you say this, spell your name for the record.
Christopher Pope. CHRISTOPHER. His name POPE.
When you're ready, we talked about this. It's going to be more of a narrative. No one's asking you questions on direct.
Yes,
But
sir.
when you're done, you'll be subject to cross-examination from Ms. Lewis if she has any questions for you.
Okay, yes, sir. She kind of switched my paperwork up, so I had it
Okay.
in order.
You put it in whatever order you want.
Questions,
All right,
dude.
thank you.
Please, though, for the record, make sure if you're talking about an exhibit, you let us know which one you're talking about.
Yes, sir. Will do.
Ma'am, are you a whore?
May I, if you don't mind, may I add to the record? Ms. Lewis made a statement.
So you're testifying now, you're adding to the record because you're testifying. This is your opportunity. It's as if you were asking yourself questions about your case,
All right.
how you're connected to it, what your allegations are. It's time to get into that if that's what you're going to do.
At this time, I will be entering into evidence exhibit 5050.
Okay, it's in evidence. What you're going to do now is publish Exhibit 50.
Okay, this is a labor agreement, MARTA, obligated transit union 732. This is the a page from our union contract book. And I am showing a paragraph that states about our seniority as far as being promoted. And it reads,
Do you have it's in evidence so you can read it. Do you have a digital copy or only the hard copy?
Yes, sir.
Oh, sweet Jesus. What?
Just talk, dude.
Is it possible to pull it up and then share?
Pardon me?
Is it possible we can have Mr. Pope pull it up and then share his screen?
Yeah, I think next time we'll do it that way. So once you get it on your screen, then share. So why don't you, here, I'll help out.
Yes, sir.
Oh, I can't wait for Cross. I knew his own direct narrative would be a mess, but I can't wait till the attorneys get a hold of it.
All right. I can't tell what's on the screen now. There, it's gone. So you find your document, and when you found it, then you screen share. Tell you what, Mr. Pope, why don't you read it to the jury? That's an exhibit they'll have during their deliberations. But I need you to be able to find stuff a little more quickly if we're going to be publishing it.
Yes, sir.
And make sure you read slowly so the court reporter can take it down.
Okay. To the jury, I apologize for the wait. It's a letter B application. Seniority shall pay the accrual of vacation and sick leave, pension rights, job opportunity, and job security as set forth in the provision of this collective bargaining agreement. Seniority shall not apply to the continuation of health insurance benefits. Such benefits shall be available only to active employees. At this time, I want to publish document, conference record, MARTA conference record, document
What's the exhibit number or letter?
Exhibit A,
Okay.
Exhibit A.
Is that something you can find on your screen quickly or not?
Yes.
Okay, then why don't you publish it?
Your Honor, I am a neurodivergent person with complex PTSD.
As you can see on the screen, it's a conference record, and that conference record is pertaining to a suspension that I was placed on for refusal to sign a conference letter for 4 occurrences.
Yep.
I refused to sign that conference sheet
Seems to be in order.
stating 4 occurrences because if I had signed the sheet, then I would have been able to be promoted to journeyman. I refused to sign it because it's an inaccurate number of occurrences. At the time, I had 0 occurrences.
I want to make sure I followed what you said. You said if you signed it, you would be eligible for a promotion, or you would not?
No, if I signed it, they would not promote me. Like, you got to have a, like Mr. English said earlier on the record, the 3 occurrences, it's a where they will promote you. You got 3 occurrences.
Okay.
And this is just a conference sheet showing that I refuse to sign it. And this is why I refuse to sign it. I would like to on that issue, I filed a grievance. When we have an incident or something at MARTA, you file a grievance and they MARTA do an investigation and they give you a response to what you file. And I'm pulling the response up.
And what exhibit is that?
This is exhibit B.
D or B?
B.
D as in Delta.
Yes.
Okay.
And in that exhibit D, can I read the whole document or?
So the documents in evidence, I'm going to ask you not to read the whole thing, just summarize it for the jurors, but they'll have it to review during their deliberations.
Okay, well, the document B just giving a determination, and the determination was that Mr. Pope, which is me, didn't have no. Well, she, the manager, and that was who did the investigation. She took all the 4 occurrences off of my record. She said that it was inaccurate placed on my record. So, in other words, I have no occurrences at all. So.
Coochie. Gotcha.
So what are you publishing now?
Publishing exhibit 36.
Okay.
That I gave Ms. Milligan, I'm assuming bacterial vaginosis.
Yeah, why don't you take that, why don't you stop sharing? So we're not scrolling through documents that are not part of the record.
And excuse me if I'm a Matlock fan.
Yeah, why don't you stop showing all the exhibits that that weren't brought into evidence? Like, If an attorney did that, that's it. Mistrial, it's over. I mean, unless it would like flash for like 1 second, one time in the trial, but just scrolling
Again,
through all
this is
these
exhibit 36.
that
This is
got
the
denied. No.
rail transportation preliminary incident report. And it,
Can you share your screen now?
yes. This document is again, it's a document made by a supervisor by the name of Trenton Kirkland, and which he made several unjust write-ups about me, and issued it to me, and it which led to get suspended. And hold on a second.
I want to dumber down the ticket. Like I want to fight that.
And this is another document of superintendent's write-ups that I received. And because of this incident that happened through 27/2023, which Trenton Kirkland wrote me up, fast forward to 4/5/2023, which is exhibit 36B.
This is theoretically his direct examination. The cross-examination should be good.
36B was a suspension from Superintendent Kenneth Jackson. And it's another conference record of suspension, and the reasoning for the suspension is failure to acknowledge receipt of transmission. I was suspended for 3 days. If I may, can I explain to you about moderator in trains? Our radios is not 100% accurate. You know, it's about 50%. You know, there's blank spots from the airport to North Springs or wherever you're operating in the east-west. There's blank spots up and down the railroad.
It's an odd strategy.
You know,
I'm not going to lie.
you can hear on the radio, hearing the radio. So this is a suspension. Also, during that suspension, after he suspended me, this individual sent the email to like 50 people in management and advised them to show up on the property to lock me up, have my police to lock me up, which is not MARTA's policy. You know, MARTA is a public transportation. At the time, during that time, I was utilizing MARTA during that time. I want to say about utilizing MARTA for, but it was not MARTA. So, but this is was not fair. It's not MARTA rules to and it kind of put a bad image on me to management. So,
Well, it's a civil action with the defense, but I get your point.
I'm trying to pull up that email, if I may.
Is that not what you just had? If you'll scroll up a little bit, you had S11 on the
This guy's
screen.
actually a plaintiff
Yes.
in a civil action and has the burden of proof. Oh, yeah.
It says, if I may read it, Christopher Pope has been placed on a 3-day suspension starting on 4/6/2023 and on 4/10/2023. Please do not schedule Mr. Pope for any work during the dates mentioned. Mr. Pope is
Oh, thank you,
not
Iris.
the property during his suspension. If Mr. Pope does show up, please have him escorted off the property by calling MARTA police. And I'm going to send that to like 50 people in management, all management, no employees, or no labor employees, all management. And that I'm here with my opportunity of moving up, being promoted.
Oh, he has no clue about
All right,
permission
don't
to
scroll
publish.
through other stuff. If
None.
you want to share another exhibit, you should unshare unless it's the very next one.
Yeah.
I'm just patiently waiting for Marta's attorneys to get a hold
This
of him
time I'll be
and ask him questions on cross.
exhibit,
It should be fun.
publishing exhibit 1Z6. Your Honor, I think this exhibit was the one I was referring to earlier when I said that it don't show clear on my screen.
Okay. If you want to publish it to the jury by handing it to a juror and they can pass it around, it's your decision.
Yes, sir. I would like to do that. This particular document was the document that denied me promotion for journeyman ET maintenance. I would like to show you guys if that's not a problem.
All right, you can take a seat and keep going while they circulate that.
Yes.
What do they hand him a device? Oh, God. So that the MARTA attorney did an opening.
Pardon me?
Yeah.
Oh, that's the end of your testimony?
Yes.
Okay. Ms. Lewis, do you have questions for Mr. Pope?
It's about to get real. When the attorneys ask him questions, that'll clarify things, I'm guessing.
Mr. Pope, do you
Here we go.
understand what an EEOC complaint is or charge?
Well, I filed an EEOC complaint.
So you have filed EEOC complaints against MARTA, correct?
Yes.
None of those complaints dealt with you being passed over for the journeyman ET radio maintenance position, isn't that correct?
I read 4 EEOC complaints, so offhand, I'm not sure.
Do you remember me taking your deposition testimony?
Deposition.
Yes, on November 6th, 2024.
Yes, I do.
Do you remember me asking you whether or not you had ever filed an Equal Employment Opportunity Commission charge for being passed over as a journeyman ET radio maintenance personnel? And do you recall saying no, that you had not?
Can you repeat that question again?
Sure. Do you recall on November 6th, 2024, you telling me that you had never filed an EEOC complaint for allegations regarding being passed over for a journeyman EET radio maintenance position?
I want to tell you that, in my amendment complaint, I did an amendment complaint and it's in there.
Correct. And you also stated that you had never filed an EEOC complaint for that particular charge, correct?
Yes.
Likewise, you have never filed a charge for violation of your civil rights under the Occupational Safety and Health Administration Act, correct?
Like I said, I filed an amendment complaint.
And so I'm speaking what you have filed with the EEOC at this time.
Yes, I understand.
And isn't it correct that that particular claim was never filed with the EEOC?
As I remember, when you asked that question, I told you that the judge gave me the opportunity to go and make my complaint. And that's what I did.
Sir, do you realize that the judge and the EEOC are two separate entities?
Yes, I do.
Okay, so I'm only speaking to what you have filed with the Equal Employment Opportunities Commission at this time. With regards to your claim that you were denied a relief break on October 5th, excuse me, one second. With regards to your allegations that you were discriminated against based on age, sex, when you complained about a hostile work environment, isn't it correct that that particular claim was a EEOC complaint ending in 05796 that related to an EEOC charge ending in 05796?
05796.
Yes, sir.
Yes, you're not gonna get my document 05796. Sir.
You need this exhibit?
If there's something that will help refresh your recollection, you're welcome to get that.
Yes, yes.
Where did he go to pick up his exhibit from the jury? Well, the judge and the jury are in the same room. So in addition to the mic, they can actually just hear him talking. So I'm sure it's better.
Okay. Just a quick recap. We're talking about the claims that you have filed in your complaint. We've already established with regards to your first claim, you had over agreement, there was no EEOC complaint filed with regards to that. We're on to your next complaint that that you were discriminated based on sex and age when you were written up for failure to follow instructions in January 2021. That was paragraph 4 of your complaint. And you testified at your deposition that those claims were related to your charge that you filed with the EEOC ending in 05796. That's correct so far, correct, Mr. Pope?
As before, I advised you that I did an amendment complaint.
Sir, the paragraph 4 of your amended complaint with regards to you being written up for failure to follow instructions in January 2021 relate to a charge that you filed with the EEOC ending in 05796.
She's referring to the amended
That's
complaint.
correct.
Jackass.
Ma'am, again, that's before and I filed my amendment complaint.
But so we're clear, I don't want us to go around in circles. The amended complaint, you're referring to the amended complaint here in Superior Court, not an amended complaint with EEOC, correct?
No, it's amendment complaint with Superior Court.
Right. So there's the litigation going on here. There's whatever you have going on with EEOC. Your amended complaint here, that's not EEOC, correct?
No.
Okay.
He doesn't even know what the judge asked.
Not sure if he
doesn't-
answered the
he doesn't
question, Your Honor.
understand.
You can, no, you should ask again. I just want us to get out of this circle of, well, but I filed an amended complaint. The amended complaint, I just wanted to be clear,
Okay.
you're referring to is the amended complaint in this case with this jury, not
get out of this
EEOC.
circle, George.
And he said yes.
Agreed, Judge. Let's leave the
I
circle.
want to ask it again, sir. Paragraph 4 of your amended complaint relates to an EEOC charge you filed ending in 05796, correct?
Yes. Number 4.
Yes, thank you. And isn't it correct that the EEOC issued a notice of right to sue without making any findings against MARTA on July 5th, on April 5th, 2023?
I was issued a right to sue from the EEOC.
Correct, on April 5th, 2023.
It's April 2023.
And you are more than aware that you only have 90 days after that date to file suit with regards to the claims in that EEOC charge ending in 05796, correct?
I'm aware now. Yes.
The notice of right to sue tells you that, doesn't it?
So you waived your rights.
Yes. Notice the right to sue. Yes.
You have to exhaust your
You
administrative
filed suit
remedies.
in this
You
matter on
failed.
September 28th, 2023, correct? I can show you your complaint that will refresh your recollection, Mr. Pope.
Yes.
All right, this is your amended complaint.
I mean, this thing is over now. He doesn't know it. But let's watch him suffer a little while longer.
That should be.
If you had a runaway jury that gave him a verdict, the judge would knock it down as a matter of law at this point.
So let me just ask you, Mr. Pope, do you recall filing suit back in September of 2023
Yes, once he rests.
in this matter
We
that
should
we're here
move to
today to
dismiss.
discuss?
You can ask me the previous question.
So she gets to ask whatever questions she wants, not, you don't get to go back or forward.
Okay, well,
But you're free, let me finish.
so sorry.
Ask
You're
him
free
what
to
you
expand your
recovered.
answer if you want to do that. If
Okay.
you think of something in response to a new question, why don't you pose the question again?
Do you recall filing suit back on September 28th, 2023 in the action that we're here today for?
No, I don't recall.
Okay, when did you file suit?
In the action that we're talking about,
Yes.
Not yet. Judge would need a motion by defense in this
I
case.
can very well get that information if I go on my EEOC
After the plea.
website right now. I'm wondering if I can get that information for you.
The question is not about EEOC. It's, do you recall when you filed this lawsuit, the one that brings us all together?
No, I don't.
Okay. He doesn't recall the specific day, which is fine. Just your question was, do you remember when you filed this lawsuit?
Yes, I can get that information for you though.
Sure. Do you recall that it was after July 5th, 2023?
In the 05796,
No, sir.
No, this lawsuit. The question is, when did you first bring this lawsuit?
again, I don't recall how I can get that information from you.
I'm stating that it was after July 5th, 2023. Do you agree?
As I just said, counsel, I can get the information, the correct information for you.
You don't know off the top of your head, though.
Not at the top of my head.
Okay, well, I'm going to take judicial notice of the fact that, give me 1 second, I'm pulling it up, the official docket, so we don't go around in circles on this. Your original complaint was filed on September 28th, 2023. September 28th, 2023 is when you filed your first complaint. I know you amended it later on, and we're going forward with the amended complaint. But the first one, September 28th, 2023.
And Mr. Pope, that is more than the 90 days that the EEOC gives you to file suit, correct? I
Please
can
repeat. Yes.
recap, sure.
Okay.
The notice of right to sue was issued on April 5th, 2023. EEOC noticed you for 90 days to file suit, and you didn't file suit until September 28th, 2023. That's more than 2 months after the 90-day deadline of July 5th, 2023, correct?
In that, yes, in that particular 05796, in that particular case, yes.
Okay.
Yeah, this incident, 2021 incident you're referring to.
Okay, I'm moving on to your next complaint with regards to OSHA. And paragraph 5 of your amended complaint, you allege that you had civil rights under OSHA that were violated when you were denied a relief break on October 5th, 2022. Is that correct?
Yes, in my amended complaint, yes.
And a conference record was drafted with regards to that incident, correct?
I'm not sure,
Excuse me, a preliminary incident report.
but I'm not sure, in my discovery that I sent to you requesting that document, you never, well, I was outside my discovery and I was never provided that document from you.
You never received a copy of your field file from me?
We're not speaking about field file now. Field file is a lot of documents, meaning like since the time I started MARTA, we're talking about the specific document you're talking about. This October 2022 document that you just asked about.
Mr. Pope, my question is, have you ever received a document called a field file or a personnel file prior to today?
Okay, you asked me a question, field file. I requested my field file from my superintendent about 6 months ago, probably 6, 7, 8 months ago.
And did you get it?
Yes, I got got it from hand to hand, not through email or anything like that.
But whether it was hand to hand or delivered on a truck, you did get a copy of your field file.
Yes, from my superintendent, yes.
Okay.
And also council just emailed me
Thank you.
my field file about 2, 3 days ago, about a week ago.
Okay.
I think that misstates the evidence, but I'll go with that. You were provided a copy of a preliminary incident report with regards to the October 2nd, 2022 denial of a relief break, correct?
Council, go ahead and show me that document.
Sure, if that will refresh your recollection.
Yes, this is a document that I have been requesting. Yes, thank you.
On October 2nd, 2022, you were written up via that our preliminary incident report was drafted based on your violation of the emergency relief policy. That's correct, Mr. Pope?
Correct, emergency relief policy.
Are you familiar with the emergency relief policy?
No, ma'am, I'm not familiar with emergency relief policy. However, I'm familiar, go ahead,
I'm sorry.
thank you. I'm familiar with, when I was a request for emergency relief, what the management have to assist them after they request for emergency relief.
MARTA communicate its policies to rail operators such as yourself.
General order.
Okay,
Yes.
let me show you what I marked as Defendant's Exhibit 1.
Can I, you mind leaving that over here, please?
Okay, I'll give it back.
Okay.
I need it. This Defendant's Exhibit 1, could you please state to the jury, what you recognize this as?
Well, counsel, like I told you yesterday, it's the first time I've ever seen that document.
Okay, I'll read the title for you. It's a new emergency relief policy. And it's a General Order 09-07. Have you familiarized yourself with MARTA's General Emergency Relief Policy?
Again, counsel, this is my first time seeing that document. And may I add this right here, if you don't mind, please. We issue general orders in our department. Every operator had to sign and date it. This document does not have my name on it, nor my signature. And that, may I say it's something, and I believe Mr. Enos, superintendent over there, can affirm that. Okay, sorry.
No, was there more you were saying? You're saying, for whatever reason, you've never seen 0907.
Well, she sent it to my email last week.
I don't mean in terms of produced in discovery, but you as a MARTA employee, you've not seen that general order before.
No, so as a MARTA employee, I've never seen it. Like it was 2009. So, like I said, everybody had to sign when they put the general order out.
And your testimony before this jury today is that you have never been aware of MARTA's emergency relief policy as an employee, a rail operator employee.
Today, I'm saying I've never seen a document that you're providing.
My question is whether or not
I never seen it.
of a policy regarding how rail operators take emergency relief when they're operating a MARTA train.
Well, there was never a policy in place, which is request for emergency relief. That's not in our contract book. Nor is it in MARTA booklet and human resource. It would be in this right here if it was a.
Objection, Your Honor. It's showing an exhibit that is not.
Well, just to leave it flat, you don't have to hold it up, but the testimony is not objectionable. You're saying that if there's something about emergency relief policy, you believe it would be in something you are provided with.
Yes, because we're on a contract, we are a union, and it really want to include new rules or new policies. They have to contact our union first within 5 days, and the union will advise its employees, and they would be in our contract book.
Mr. Pope, have you looked in the union book for the emergency relief policy? And is that something that you've done prior to today?
What union book are you referring to?
The one that you just referred to that has all of MARTA's policies, safety policies.
This book, this is the union book I'm referring to right here.
Prior to today, Mr. Pope, have you ever reviewed MARTA's emergency relief policy?
Miss Council,
So
That
yes,
rule-
no question. You can answer it and then explain.
if she's talking about this book right here,
She's not talking about a book. The question was, have you, Mr. Pope, ever reviewed MARTA's emergency relief policy?
again, as I stated before, emergency relief policy, I've never seen it or reviewed an emergency relief policy.
How did you know of the concept emergency relief? You actually brought it up. How did you learn about emergency relief?
Oh, yes, great, thank you, that's a good question. Emergency relief is when the operator, operating and they get tired or they have to use the restroom or have to get some water or something like that. They just come over there and request for emergency relief.
Okay, I got that. How did you learn that you could do that? How did you learn I can come on the radio and say, this is Unit 17, emergency relief? Was that in a book? Was that a supervisor who taught you about emergency relief?
No, it was not in the book. It's just what everyone was doing, if you needed to get off the train, but you just break. That's what we just request for emergency relief.
Okay, and you learned that you could do that you could get on the radio and say, I need emergency relief because you saw someone else do it, or you were trained to do that, or you read it on a piece of paper?
No, I didn't do it. I mean, other operators before me, under me, came before, after me. When they use the restroom, if they operate the train, they request for emergency relief. They call it emergency relief. And they go use the restroom.
Right, how did you learn to do that?
Watching other operators.
Okay, there we go.
Yeah. Add something in regards to the
About emergency relief or something different?
the general order emergency relief.
Okay, let's wrap that up.
The general order. You can she can find the general order inside of the matter. I mean, with the SOPs and things like that. She can find general order and the meaning of the general order, and when it's given to us, she can very well find that herself.
Okay, I think she's more focused on you finding it, but why don't you ask your next question?
Sure, Your Honor. Mr. Pope, with regards to your paragraphs 3, 6, 7, 8, and 9 of your amended complaint, your deposition testimony was that you never filed any EEOC actions with regards to those charges. Is your testimony changing with regards to that today?
Please.
Sure. With regards to paragraphs 3, 6, 7, 8, and 9 of your amended complaint, your deposition testimony on November 6, 2024 was that you never filed any EEOC actions with regards to those charges. With regards to those complaints. Is your testimony different today?
So I said that I was able to make my complaint.
Your testimony is not different.
No.
And so I'm clear, and maybe others in the room, when you're talking about amending your complaint, you don't mean amending a complaint with EEOC, you mean amending your complaint that is the lawsuit here in Fulton Superior Court.
Yes.
Okay.
No further questions, Your Honor.
All right. Mr. Pope, if you had an advocate on your behalf, that person would have a chance to do what we call redirect, and you'd be able to provide additional testimony that's responsive to the questions that Ms. Lewis just asked. Do you have anything more you want to share with the jury based on the questions that Ms. Lewis just asked you? I'm not going to forget, I promise this time.
Yes. Also, from my understanding, Ms. Lewis was asking me the deposition and EEOC complaints that I made. And I recall after she asked me about my EEOC complaints, I told her I was able to amend my complaint with, not EEOC, but with the courts. So that's about it.
Okay. Any recross, Ms. Lewis? Okay. Any questions from the jurors? If you need a note card, grab a note card. But if you've got any questions for Mr. Pope, now's the time to write them down and get them to Deputy Gordon, please.
Well, that was just craptacular. I would say the Titanic went better than that. Yeah, I don't know how they didn't get out on motion here. A well-placed motion to dismiss probably should have resolved this.
Thank you, sir. Are there more coming? Okay.
Okay, it looks like there's more stupid before the break. Then we'll skip the lunch break. I guess there were closing arguments already. We'll get there. Or maybe not. Maybe not, because I think there was a motion to dismiss, a motion from the defense, which there should be at the close of his case. We'll see. I don't know. I'm getting little updates, but
All right, Mr. Pope. Are MARTA employees required to review policies as part of their training? Like the policy on emergency relief, things like that. As you're getting trained for your job, whether you're starting or you got a promotion, are you required to review the policies?
Yes, the policies, well, training, okay, you talk about training, meaning like when you first start working at MARTA or training,
Well, let's take both. You first start working at MARTA. Are you required to review MARTA's policies for employee conduct and anything there might be, like a policy manual?
review, do they give us a policy? I'm not sure, during training, they don't give us no policy about emergency use in the restroom.
Okay, but let's step back from emergency relief. Are you saying that spiral bound book is the only thing you're given when you're hired and you're being trained for a job? It's that, and there's not also like, the vacation policy if you want to put in for leave, or information about retirement benefits, or if there's a 401k, or some jobs have dress codes, and that's a policy. It's not the law.
Yeah.
And so you're given a policy set of documents. It may be a binder. It could be a thumb drive. I don't know. But I'm wondering, the question is, when you were being trained, whether it's day one, forever, your first time at MARTA, or you got a promotion, are you given policies that you are expected to review and know?
Oh, yes, yes, we're given policy.
Okay, but you're saying that the emergency relief policy or whatever it would be wouldn't have been in that collection.
I'm saying it's new. I've been at MARTA 13 years, and I've never seen that document, emergency relief. Emergency relief dated 2009. And I'm saying if that is an official document, then Miss Lewis should have that, the part 2 of that document that,
Where you sign.
employee has to sign it. There's just, it's a rule. That's not, I'm not saying it was a rule.
Okay. You had exhibit A and D, both of which are in evidence.
This is
A, I think, was the write-up that you got, where you were suspended, and then D cleared that up and reversed the suspension. I think you were given back pay or something. The question is, what are the 2 dates for those things? When did A happen and when did D happen?
A happened 9/21/2022. That's when I went in for in the office. Yes,
And then when did D happen? When was it cleared up that you shouldn't have been suspended?
D happened December 7, 2023.
So
That's when I was issued the determination.
a determination?
Yeah. Yes, grievance response determination.
Okay. So,
Wait, I'm sorry, decision on the grievance.
so 2 years later.
No, December 7, 2023.
Okay. And I must have misheard. When did A happen?
9/21/2023.
Oh, 23. Okay. Got it. Okay. So, 3 months later.
Yes, that's exactly 9.
Okay.
I don't know.
Got it.
Yes.
Tell the jurors again, please, what you were suspended for in April of 23.
Can I say the words that she said, or
Sure. I need for you to tell me what went on.
that I'm not on that whole shit. I'm not with that.
And it may be March of 23, as I look at your complaint and I'm reconciling the
Yes.
juror question.
It was March of 2023, and for the record, allegedly, this is what the superintendent, well, the super, hold on.
This should be the Supervisor Kirkland situation.
Yeah, Supervisor Kirkland situation. Again, it was a write-up, and when you get wrote up, you have to into the person who's over the supervisor to call you in for a meeting to stand, I guess, to visit your charges. And on 4/5/2022, that's when I had my meeting from 3/27/2023.
Okay.
In other words,
The incident was in March. The actual write-up was in April.
yeah,
We're talking about the same thing.
yes, well,
And what were you written up for? That's the question.
okay, 3/27/2023, supervisor wrote, failed to follow instruction, failed to acknowledge receipt of transmission, making untrue, dishonest, or misleading reports, failed to remain alert, failed to secure the train doors. And can I speak about this document?
So, the question is, what were you suspended for? And you're reading the things that they said you did.
Okay, well, 4/5/2023. That's the meeting for this date right here.
Okay.
For these charges right here.
Okay.
You know, and in 4/5/2023, the superintendent is speaking about the 3/27/2023 incident, and he summed it down to failure to acknowledge receipt of transmission and repeating the transmission when required to. So that's what he wrote me up for.
Okay.
I mean,
And what was the
really-
consequence for allegedly doing those things? Were you suspended or?
Well, you got suspended for 3 days, but consequence, according to the rule, they gave me this is not really the consequence. This is something that he just did. 3 day suspension. I have the rule book with me over there. If
So the rule book is something different from this book you keep picking up?
yeah, the contract book, rule book.
And would the rule book have something about emergency relief in it?
The rule book will only have pertaining to emergency relief, use the restroom. It would have we're not supposed to actually use the restroom like on a train or something. Like we have to request for someone to, come relieve us. Basically just say only that you're not supposed to use the restroom on the train, like actually use the restroom, and you get, suspended or termination for that.
Okay. In connection with your 3-day suspension for the radio scenario, you shared an exhibit that was an email that Supervisor Kirkland sent out saying, hey, if Mr. Pope shows up, he needs to be escorted off the property. Do you remember that?
Yes, it's Supervisor Kirkland, Superintendent Kenneth Jackson.
Okay, Jackson. And that was in connection with you being written up by Supervisor Kirkland. Is that correct?
There you go, sir. Yes.
Okay, so Superintendent Jackson sends out that email. Do you know if it was policy for the superintendent to send an email out to other managers when a MARTA employee is suspended to make sure that that MARTA employee doesn't try to report for work?
I don't think that's policy, sir.
If you don't know, you don't know.
No, I don't know, but
So if you don't know, then that's your answer to the question. The question was, is it policy for MARTA to do what Superintendent Jackson did, which is say, look, here's an employee who's suspended for these 3 days. If you see him on MARTA property, you need to call MPD to have him escorted off.
that's not policy, sir. Thank you for saying the whole part of the email.
Okay.
In part, by the police.
Okay. Last question. Tell the jurors why you think you were discriminated against on the basis of age. That's one of the things that you brought up, and the jury wants to understand why you think that.
I think that because I know there's a little name, but but MARTA, I know the people for the position that I applied for. Outside and internal and external employees. And I feel like I was retaliated for filing EEOC complaints.
What?
Ms. Lucy, oh, I'm sorry. I thought you were done. My bad.
Yes, and retaliated against for exercising my human right to go and use the restroom.
Is he? Is he crying?
Okay. Ms. Lewis, do you have any questions for Mr. Pope based on the questions I just asked?
I had a question, Your Honor. Just one. With regards to the EEOC complaints that you have filed, it is your understanding that none of them returned with any findings against MARTA, correct?
Other than right to sue letter, no. Other than right to sue letter,
Did your notice of right to sue
I received a notice of right to sue letter.
that made no findings of ill intent, employment discrimination against MARTA?
Well, they didn't send me no email about MARTA.
No, the question was, did the letter that you received, the right to sue letter from EEOC, did it contain any findings by EEOC that MARTA had done anything wrong? Or did it simply say, we're done here. If you want to sue, you have a right to sue? I'm paraphrasing, but you understand what I'm asking? Yeah. So was the letter more along the lines of, hey, we are not finding in your favor here, but if you want to sue, you have a right to sue?
Yes, I got from it. We're not finding in favor of MARTA or you. However, you have a right to sue.
Okay, it was a finding in no directions. We make no finding, but if you want to sue, you have a right to sue.
Based on, I have a right to sue based on claim the findings that
Okay. Anything else, Ms. Lewis? All right. Mr. Pope, you can, I'm gonna have you stay right there because we have a few things we need to work through. We are gonna take our lunch break now, ladies and gentlemen. I'm gonna ask you to be back as close to 1:30 as you can. During this lunch break, it's fine to be together. You don't have to be with each other. Just don't talk about the case. No outside research. When you get back, we will figure out what's next in this case. There'll be a few things I need to talk about with the parties before I can bring you back out here. And then we'll do that as soon as possible. Any logistical questions? No? All right. Good luck. See you soon.
I'll begin with paragraph 4 of.
Okay. All right. That's something you're free to address in your closing. Okay.
yes.
All right. So other than that, which would be something that you would argue in your closing, do you have any other evidence you want to present, or are you resting?
I'm resting.
Okay. I'll have Mr. Pope do that in front of the jury in a little bit, Ms. Lewis, but since they're out in the jury room right now, I'd like to turn to whether the defense has any motions now that Mr. Pope has rested.
Motion for direct verdict as to all claims.
Okay. Why don't you come to the podium and explain to me and Mr. Pope what the basis for the directed verdict is.
Your Honor, if I may proceed by paragraphs in the amended complaint.
Okay, let me get that in front of me, please.
This makes all sorts of sense. Exactly what should be happening. He has the burden of proof and he didn't make his case.
All right, I've got it.
I'll begin with paragraph 4 of the amended complaint, Your Honor.
Okay.
Particular paragraph relates to an EEOC charge that, as plaintiff testified to, ended in 05796. The notice of right to sue for that particular charge was issued on April 5th, 2023. And there was a 90-day window wherein plaintiff was able to file suit. That 90-day window expired on July 5th, 2023. And as the court has already taken judicial notice of, the complaint was filed September 28th, 2023, more than 2 months post the deadline.
Someone's phone is unhappy.
It's my MARTA cell phone. Everybody is calling.
Uh-oh.
Wondering why.
They should know you're in trial.
Should know that. So as the law would have it, 42 USCA section 2000E-5, plaintiff is barred from asserting any claim with regards to that particular charge. And that would relate to his claims in paragraph 4 of his amended complaint.
Do you have Georgia case law that applies the Title 42 bar?
One second, Your Honor. I have not cited any Georgia case law applying the title, did you say Title 42, Your Honor?
That's what you cited to me. You said it was 42 US Code 2000E-5.
That's correct.
And I don't have that provision in front of me, but I trust it says what you said it says, but it's peculiar that a federal statute can say you can't sue in state court. And I trust that's what it says, but, or maybe you just can't sue at all, doesn't tell you where. And I'm wondering if you, in the course of your work, have encountered Georgia cases that apply it and say, hey, this lawsuit is out of time because of this federal statute.
Your Honor, and I'm going to pull these up as I cite them to you. Doss v. City of Savannah, 290, Georgia App, 670, 2008. That
670?
Yes, sir,
Okay.
670. So sues, it very clearly, it makes that part bold because it stand out. It's a restriction, so they make sure it stands
Okay,
out.
Okay.
that's just going to be too painful.
They embolden that on the notice of
Specific
right to
Georgia
sue.
case law.
Okay.
We're getting to the point here now, people. I skipped the boring
All right.
argument.
Anything else?
I think that's it, Your Honor. I think we've addressed all of the applicable paragraphs, and I just ask that you grant the motion.
Okay. So, Mr. Pope, Ms. Lewis is arguing that I resolve your case now in MARTA's favor, take it from the jury and enter what's called a directed verdict in favor of MARTA for different reasons depending on the paragraphs we're dealing with. For paragraph 4, the argument is you missed a deadline, this 90-day window to sue. For paragraph 5, it's sort of a variety of arguments, but basically you didn't present any evidence to the jury as to how the action that Supervisor Bell took in October of 22 was discriminatory on the basis of either gender or age. And then for all those other paragraphs, it was because you didn't file an EEOC charge concerning those alleged violations of your employment rights. So you can respond in whatever order you want. I'm just letting you know it's a different argument for different paragraphs.
Okay. Well, I came down to Fulton County and filed an amendment complaint to my original charges that she referring to.
I don't think that we're working off the dates in the amended complaint, but Ms. Lewis has given you the benefit of your original complaint date, which we know was late September. So you first came in here and said, here's Pope versus MARTA, and it was assigned to me in September of 23. And she's pointing out that that is outside the 90-day window that you had to file suit for paragraph 4 only. It was inside the window for paragraph 5. And then for all those other paragraphs, there was never an EEOC complaint or whatever the term would be. And so you actually shouldn't be suing yet because you didn't exhaust your EEOC remedies.
So you were seeing that I have to file EEOC complaint before I file a suit?
I'm not saying anything. Ms. Lewis is saying that the case law is that you need to file an EEOC complaint before you can sue an employer in state or federal court for employment discrimination on whatever grounds. Yours is age and gender, but that you're supposed to start with EEOC. And I think that was the 208 Georgia appeals case. You say it stands for that proposition? Okay. So you're free to say she's wrong. You can say here's a case that shows she's wrong. I just want to give you a chance. I got to go read the cases, but I want to give you a chance to make your argument. So I hear that before I go back into my office and do a little research.
Oh, okay. Well, I filed EEOC complaints. I have like 3 over here.
Well, they're not in evidence, so I don't know what you did or didn't do. What is in evidence is that you filed a EEOC complaint in connection with the paragraph 4, where the radio situation, and that one, you didn't file your lawsuit within 90 days of getting your right to sue letter. Paragraph 5, which was the emergency relief situation, you did file an EEOC complaint and you filed your lawsuit within that 90-day window. But for all the others, there's nothing in the evidence now, and your evidence is closed. You don't get to introduce any more evidence. There's nothing in the record that you filed an EEOC complaint, for example, about you being suspended by Superintendent Brown for refusing to sign an attendance form. Maybe you did file an EEOC complaint, but I can't consider that one because it's not in the record.
Okay, what about number 3? It's not in the record?
I don't think there's any EEOC complaint that's actually in the record, like the complaint. So what we've got in the record would be testimony, things you said. That's also evidence. And you answered a bunch of questions when Ms. Lewis was cross-examining you. And she explored with you 2 EEOC complaints. One of them ends in 796, that relates to paragraph 4. And the other ends in 108, and that relates to paragraph 5. There's no evidence, Ms. Lewis is contending, of any other EEOC complaints that are in the record. So that's our starting point. Now, if you think you testified about others and you named them with specificity and gave dates of when they were filed and when you got your right to sue letter, you can tell me about that. I don't remember that testimony.
Okay, what I'm asking is number 3.
Paragraph 3?
Paragraph 3 that she said this.
I'm looking at paragraph 3. She says there's no EEOC complaint or charge in evidence in connection with paragraph 3.
So for the record, I filed my lawsuit September 27, 2020. September 23, 2023.
Okay.
Yeah, and she's insinuating that my amendment complaint, paragraph 3 is not in that, of my understanding.
Is not in your original complaint?
No, my amendment complaint.
Repeat what you said. I'm sorry, I didn't follow you.
My amendment complaint, the one paragraph 3.
Yeah.
Amendment complaint.
What about it?
The lawsuit that I filed, she's saying that that's not, paragraph 3 doesn't have anything to do with that lawsuit.
No, that's not what she's saying. And your lawsuit is now the amended complaint. Your original complaint you've amended. So paragraph 3 is part of your lawsuit. What I heard Ms. Lewis say is that paragraph 3 is not the subject of any EEOC charge that you brought. She's not saying you filed your lawsuit too late as to paragraph 3 or outside the 90-day window. She is saying there is no 90-day window because there's no evidence in front of Judge McBurney that Mr. Pope complains to EEOC about having been discriminated against and passed up on promotion to journeyman ET radio maintenance. That maybe that happened, but that's not something that you complained to the EEOC about. And because you didn't, you are prevented from suing. You got to go EEOC first, get your answer, and the answer is you win, you lose, or right to sue. And if it's right to sue, then you could bring paragraph 3. That's how I'm understanding her argument. I want to know your response to that.
I mean, I disagree. I mean, it's how you understand her argument, but I mean.
Tell me what part are you disagreeing that are you saying I don't need to go to EEOC first? Or are you saying you did go to EEOC? Or you're saying she's mistaken about what?
Oh, no, I'm saying that whatever she got to the podium and said, that's something that I have to go do my research on. But as of right now, I don't know based on what she said.
Okay, so I have to do a little research, and that's what's gonna govern how I manage this. But you don't have in front of you cases that say Ms. Lewis's argument is incorrect. Is that right?
Well, I have to check, look at my documents.
Okay, I'll let you do that, because I'm gonna need to go do a little research.
Okay.
Anything else you wanna share with me, in response to Ms. Lewis's 3 arguments?
The motion's now, my friend.
Not right now, sir. I don't have anything right now
Okay,
at the moment.
all right, Ms. Lewis,
Yes,
did you find me more cases?
I have some cases, citations,
Great,
paragraph 5. In particular, with regards to the standard by which age discrimination has to be established, 498 at 3rd 9. Let's see. It's at 15, page 15, and that's a 2007 case. I wanted to give you more on the McDonnell Douglas analysis if you know.
well, I don't know that you need to right now because your argument is in effect that no evidence was presented that gender or age played a role in the action that Bell took. And so that's a sufficiency of the record issue, as opposed to what's the test. I'm more interested in cases that say 90 days means 90, and if you file outside that. I found, I think, a few federal cases, but I need to go back into my office and read those. Did you have anything else?
Not with regards to that particular point, I
Okay,
have those 2 that I cited, Dawsby City of Savannah and Collins versus Department of Transportation.
okay. All right, thank you. Deputy Gordon, if you would let the jurors know that we are working hard on a few legal issues. We have not forgotten about them, and they should be at ease. Okay. I got to go do a little research, and I will come back to see if either of you wants to add anything to the discussion. Let me ask this last question. Would I find case law in your motion for summary judgment, or you are citing to me now what you cited in your motion for summary judgment? I should say different or additional case law.
It should be, it might be the same, Your Honor.
Okay. How about this? I'm going to go do some research. Please look at your motion, and if there are other cases, email those citations to Mr. Pope and to me.
Oh, yes, Your Honor, I'll do that.
Thanks.
The 9.
Okay, Ms. New, are you ready? We are about to record. Ms. Lewis, you are moving. You've moved for a directed verdict. Is there anything more you want to add? I did receive an email that I think you also sent to Mr. Pope that listed additional case law in support of your argument. Beyond that, anything you want to add? Okay, Mr. Pope, you had the same break as everyone else. Is there anything you want to add in terms of your response to Ms. Lewis's motion?
Jurisdiction.
Well, it's ridiculous. I mean, if I may speak, this
It's
trial
ridiculous.
almost close to 2 years. I came before you on, I don't remember what day it was, and got my lawsuit amended. This is a attorney. She licensed attorney, and for this to drag out so long and easy, she's filed this beforehand, trying to get it, I guess, overturned or whatever the case is. But it just, I don't understand. I mean, if I'm an attorney, if I'm a judge or attorney, I'm gonna cut this loose. I'm not gonna drag that out just to say, hey, you didn't file it at the right time. I mean, you guys get paid to do this. So this is really
It's frustrating.
well, not so good frustrating, just embarrassing for this not just me, it's embarrassing for the law, the court. I mean,
No, just for you.
you guys know the law.
You are the only one who needs to be embarrassed here.
I'm not making no excuses or anything, but
You don't need to make
still,
any excuses.
I mean, I still disagree with her motion, so
Okay.
I hear from you, but
All right. Well, let me start by addressing your comments you just made. I think they are well put, and I agree with you. This is a case that I think could have been resolved through filings rather than a trial a while ago on technical grounds. That's what I'm going to end up ruling here is mostly on technical or procedural grounds. And in a very feeble and intentionally so defense of MARTA's handling of this, they made those arguments in the motion for summary judgment, but that was too late. There was a deadline in this case.
It's fun. He doesn't even realize he's lost yet. Like, I mean, if like that right there is the ruling. If I'm making these, if he made his ruling on technical grounds, this party is over, and should be.
For a motion for summary judgment, I don't know why MARTA missed it. That is not anything I can control. But one thing I'll tell you, Mr. Pope, is that I'm not authorized to, on my own, look at a case and say, this is barred by a procedural statute of limitations, and this is a bad claim, and this is a good claim. I might know that that's legally the correct ruling, but one side or the other needs to say, Judge, we're asking you to do this. Otherwise, judges could just look at a lawsuit when it's filed and say, I don't like this, and toss it out. And that wouldn't be correct, wouldn't be fair, wouldn't be due process to either side. You are correct that some of the reasons why I'm going to rule the way I'm going to rule have been true since you filed your lawsuit. And they are only now being brought to me in a timely way, if you will, to rule on. It's perfectly appropriate to make the arguments that Ms. Lewis is making now because we got to trial. But we probably didn't need to get to trial if everyone had been up to speed on the case. But here we are. I mean, we're here. I need to rule on the motion that's been made. I'm going to break it down into the individual pieces.
I'm sorry, there's a record that has been made in regards to, I guess, competency and proceeding with this case. I just want to address that very briefly, Your Honor.
Well, I want to be clear. I haven't, nothing I've said has been, should be construed as me saying anyone being competent. You have a huge caseload. My observation was, I think there were opportunities for us to tackle this case in the way we're tackling it now that were missed. That's not a competency. That's a workload issue.
Oh my God. Shut up. You're about to win. I think she realizes that. The judge said, you know, it would have been nice if you brought a motion earlier, which is correct. Don't get up in your feels. Just sit there and take your win.
Sure.
Reflection of your comments more so, Mr. Pope's, but if I could, you know, briefly, Your Honor, address that. On the day of trial, when this case was first noticed for trial, plaintiff filed an amended charge. Well, his first charge or complaint in this case had 2 sentences. There was nothing for me to go off of. When he refiled the amended complaint, there were an additional 10 paragraphs, a lot of which we had to sort through and figure out what he meant. When sorting through that, we realized that he had filed EEOC charges that MARTA had never been noticed of, and that MARTA had no proof that had resolved. And so we had to rely a lot on the EEOC in establishing what he had filed and what exactly he had alleged, because that has a lot to do with the dispositive motion in this case. And unfortunately, there was not a quick response from the EEOC in regards to what happened. So when he says,
bullshit, wrong. A dispositive motion should have been brought earlier in this case. It's not a big deal. You did a nice job at trial, and then you made the appropriate motion. You did nice work, but it would have been better had you filed a motion to dismiss timely. It's not the end of the world. It's not incompetence. It's not unethical. It would have been more efficient. Now grow up and take your win.
that I'm a lawyer, I am licensed, I should know the law. I do. A lot of that does not depend on what I know or what I'm capable of doing. It depends a lot of times on the responses.
Sure.
So I just want to make that clear. We have not belated in this case at all. We filed discovery timely, we responded timely. There was a mix up in timeliness of his filing because he filed the same request twice. That was it. But as far as responding and making the case for MARTA, I think we did the best we could with what we had to go off of.
Okay, those are all fair points. And you are a lawyer, not a magician. And you don't get a wave a wand and EEOC files land in your lap. So I appreciate you flagging that. And as I was in the midst of saying, we are where we are now. We are in trial. You've rested. We'll get you to rest in front of the jury in a minute. But you resting triggers the defense's opportunity to make a motion for a directed verdict. And if I conclude that it's appropriate to grant a directed verdict, I should do that. It's a pretty steep hill that the defense needs to climb because they are asking me to take the case from the jury and decide it myself. In fact, the standard is that it should only be granted if there is no conflict in the evidence as to any material issue to your claims, and if the evidence that has been introduced, if we treat it reasonably, demands a particular verdict. That's the test that is commonly pronounced. That applies more to the sufficiency of the evidence. I think we have some procedural bars here that apply as well, which I think is triggered in part. You're not frustrated. You're saying you're embarrassed for the court and for MARTA's lawyers. Things that, in theory, if we knew everything about your situation, could have been argued earlier. But much as I'm agreeing with some of what you're saying, I'm agreeing with some of what Ms. Lewis is saying, which is that your approach, because you have elected to proceed on your own, has been a little scattershot, and you are trying to cover the bases as best you can see, and as best you understand them. But that's been manifested by an exhibit list that goes to 108, and then all of a sudden we're talking about exhibits that are 1Z.
And by a little scattershot, I mean effing terrible, just god awful, just stupid, to the point of making the defense's case. And not being and not being able to speak the English language. Bad.
6 and S10 and letters and numbers. And so I think it's fair pushback from Ms. Lewis to say it was kind of hard for me to tell what exactly I'm up against. Had you had a lawyer, that lawyer would have pledged your case ABCD, crisp, crisp, crisp. And then Ms. Lewis could say, here's why that doesn't work. Here's my motion. Oh, this one works. We got to go forward on that one. And nope, I'm done hearing from the two sides. I'm going to talk for a little longer. So we're working with your complaint, amended complaint as drafted. That's the universe that you pled. Paragraphs 3 and 6 through 9 all relate to conduct for which there is no evidence before this jury that an EEOC complaint was ever filed. In order for you, Mr. Pope, to bring into state court, the Superior Court of Georgia, any claim pursuant to Title VII, discrimination on the basis of age, on the basis of gender, and those are your two bases, you must first file a charge with the EEOC. And the proposition, the support for that is first the federal statute, 42 USC 2000 lowercase e -5, subsection E, but also DOSS versus City of Savannah, 290 Georgia Appeals 670 at 675. That is a threshold requirement. If you're going to bring an employment discrimination claim in a Georgia court, you start by first administratively pursuing that with the EEOC. And I find that there is no evidence in the record before the jury that you did that in connection with 3, 6, 7, 8, and 9. As to paragraph 4, you did pursue things with the EEOC, and that's their case number that ends in 796. And you received a right to sue letter that was issued on April 5th of 2023. You've testified to that effect. That right to sue letter very clearly gave you a 90-day window in which to bring your lawsuit. Your initial lawsuit, not the amended complaint, your initial lawsuit was not filed within that 90-day window. Obviously, your amended complaint was filed even later, but it's your first one that would stop that 90-day clock. But it was filed a couple months after that deadline had expired. In Collins versus the Department of Transportation, 208 Georgia Appeals 53 at page 56, our Court of Appeals said that in order for superior courts in Georgia to have subject matter jurisdiction, there must be a timely claim brought here pursuant to the EEOC notification that you can file a suit. That's that 90-day clock. And timely means within 90 days. More specifically, in Surrell, SURRELL, versus California Water Services Corporation, which is at 518 F 3rd 1097 at page 1104. It's a Ninth Circuit case. The Ninth Circuit Court of Appeals stated very plainly, once a person receives an EEOC right to sue letter, she has 90 days to file suit, period, full stop. And the allegations in paragraph 4 were not brought to court within that 90-day window. So I'm directing a verdict as to paragraph 4. Paragraph 5, you did file a different EEOC complaint. It ends in 108, and you did bring your original complaint within that 90-day window. And so that was timely filed, but I find as to paragraph 5, as well as to any other relief for which you timely brought suit, and that relief all relates to your overarching allegation, which is that you were denied either advancement, meaning promotion, or raises, compensation at MARTA on the basis of gender and or age. So any claim that was timely asserted that you were discriminated against on the basis of your age and or your gender, that those are not adequately supported by the evidence that you admitted during your case in chief. In order for you to survive a motion for a directed verdict, you must have made this preliminary case that you were a member of a protected class, male, you're a member of a gender. You haven't established what the age differential was between you and someone who either got paid more than you and was promoted. Was it 1 year or 10 years or 20 years? You haven't established specifically who was considered for whatever promotion you sought, and that person's gender and age. There was a general claim by you when you were testifying that younger females got advancements that you didn't, but not a definition of what younger means or frankly who those people were. Nor did you make any showing that these people were less qualified than you for the promotion or the raise. And that covers all of those allegations that may have been timely filed. I find that the record before this jury would not enable them to reasonably and rationally, based on this record, if Ms. Lewis simply said MARTA rests, for the jury to say, yes, we conclude that Mr. Pope has shown by a preponderance of the evidence that these other people who got promotions or got raises were younger, were a different gender, were less qualified, and here's how much younger they were, different gender, just as different gender, but that they were either just as qualified, and so the only explanation could be gender or race, or they were less qualified, and so they ought not to have received that promotion or that raise over Mr. Pope. Absent that kind of evidence, it's inappropriate for the case to go to the jury, or said conversely, it's appropriate to grant the motion for a directed verdict, which is what I will do when the jurors come back out here. Ms. Lewis, is there anything else you want to get on the record? Mr. Pope, is there anything else you want to get on the record before the jurors come in?
Oh, no, sir.
Okay. One last thing, when the jurors come back out, I'm going to ask you, Mr. Pope, if you have any other evidence or if you're going to rest. I assume you're going to say rest. That's what you told me. Then I'm going to tell the jury what we've been working on. I'm going to have the jurors go back into the jury room. I'm going to thank them for their service. And then they may be willing to interact with you all if you want to ask them any questions about anything. I'm just letting you know you may want to stick around in case they want to come out and give feedback. They're not obligated to do that. They may all say, we'd like to leave. But if you know you don't want to interact with them, I don't want to ask them to come out here if they're interested. Mr. Pope, are you interested in that at all?
Oh, no, sir.
Okay. Ms. Lewis?
Sure, yeah.
Okay. Well, we'll see if they are interested. Pardon me?
Only if they're interested.
Right. No, that's always the ultimate threshold. But if neither side was, then I don't even broach it with them. Okay. Let's bring the jurors out, please.
All right. I can close it down here, or we can wait and see if it, but you can't really see it. I think the jurors would be cranky. Although really it's nice. They get cut loose now. They don't have to deliberate, which would have taken them all of 30 seconds. I mean, this would be more fun if we could see the annoyance on the jurors' faces.
Ross and jurors. Joseph President, you count for?
Welcome back, ladies and gentlemen. Thank you for indulging us as we worked through a number of issues that we had to tackle. Mr. Pope, before we broke for lunch, we were going to work through making sure we had the exhibits all in one place. And then you were going to let everyone know if you had more witnesses to call or if you were resting.
Oh, yes, resting.
You're resting. Okay. Ladies and gentlemen, during the break, both the lunch break and your extended bonus break after lunch, we took up the legal process that occurs after a plaintiff rests in a civil case. One thing that a civil defendant can do at the close of a plaintiff's case is move for what's called a directed verdict. That's when the defense says, Judge, based on the record that's been made by the party that had the burden of proof, we think that you should rule in our favor. In other words, the case does not go to a jury to deliberate because either there's a procedural bar or the evidence is such that it would not be rational for a jury to come down with a verdict in favor of the plaintiff because either the evidence is too conflicting or it's insufficient. That's an argument that Ms. Lewis made. Mr. Pope argued in response. I had to do a bunch of legal research because it involved employment law. And it turns out that it's not common to do employment law cases in state court. It usually happens in federal court. So I learned a bunch of federal law as well. But I have ruled in favor of the motion for a directed verdict, which means the case is now closed. I have entered orally, or I am now entering orally, judgment in favor of MARTA. And your jury duty is complete. I know you only heard half the story, and that may seem like not how the process is supposed to work, especially since in one of my mini sermons yesterday, I said, when there are intractable disputes, we turn to members of the community, U13, to resolve those disputes. But there are some guardrails in place so that we don't send you to deliberate when the evidence doesn't justify deliberations. And that is what we ran into in this case. So on behalf of Mr. Pope, as well as MARTA, I want to thank you for your service and your time. In just a moment, you're going to go with Deputy Gordon back to the jury room. I'm going to come back there to thank you again, get you letters that provide proof of service, answer any questions you have, and give you your final operating instructions. Okay, so if you grab your notepads, head to the jury room. I will be there in a second.
All right, juror. Okay, all right.
Oh, there's the jury. After all that.
You know, I'll take them. Thanks. I'll give them to you. Mr. Pope,
Yes, sir.
anything else you want to get on the record?
Oh, no, sir.
Pardon me? I want to thank you for your preparation and your professionalism. I will tell you going in, I was a little nervous because I've had pro se trials before, and sometimes the self-represented litigants get frustrated, and then they sort of take that out on the jury or this or that. And you were calm and poised and as organized as you could be expected to be as a non-lawyer. And so I want to tell you, what's your official title? Are you a rail operator?
Yes, sir.
You are the best rail operator, non-lawyer attorney that I've had in here. So I want to thank you for that. You are justified in leaving here feeling disappointed and frustrated, but it's not because you didn't try. And I want you to know it's not because in any way I treated you differently because you were representing yourself. I worked hard to treat you with the same respect as I treated Ms. Lewis. And the rulings I made had nothing to do with you being a non-lawyer and everything to do with my understanding of what the law requires. I didn't know there was a 90-day rule that if you get a right to sue letter, although it says it in the letter, you got to sue within the 90 days. But the law is very clear about that. And so I need to apply that. And so this is not a Judge McBurney that Mr. Pope's a non-lawyer, so let's railroad him. Not at all. You were very sincere and passionate in what you were litigating. And there may be other avenues of relief for you. And you may want to apply to law school. You should think about that. But I want to commend you for your professionalism in this because pro se litigants don't always handle it in the same way that you've handled it. So thank you for that.
All right, no problem. Thank you.
All right. Ms. Lewis, I want to thank you. You worked with Mr. Pope in a exceptionally professional way, in the same way that some pro se litigants don't always comport themselves here when things don't go well. I have had lawyers who exploit the fact that there is a non-lawyer on the other side. And that's not how you did this at all. You were very patient and understood why things might take longer and rolled with it when I might have indulged Mr. Pope more than I would have Attorney Pope representing someone suing MARTA. So you are to be commended for your patience and perseverance in this and for powering through as you recover from whatever ick that you had. So thank you for that. I will check with the jurors to see if anyone wants to stay. And I won't leave you hanging out here. If they all take off, Deputy Gordon and I will poke our heads out to say, here's the situation. Okay. All right. You need to make sure you settle up with Ms. New.
sure she's good. Your Honor, I'll also be filed tonight, now that I know my time, motion for a written speaker, as the court consider that we need a hearing on it.
Okay, we'll work through whatever gets filed.
Thank you.
All right.
Have a great day.
All right, take care. All right, well, thank you, everyone.
Thank you, Your Honor. Hopefully, my last trial.
No more trials? In-house doesn't do trials?
Yes, but I'm hoping I do something else in-house, not this.
Oh.
So. Do you have everything you need for me?
I do, I sent the information that I got this morning, they've already created a job number and everything, so.
All right. Looks like that's all we got. Yeah. I mean, the right thing happened. It was so obvious. It could have been done on motion. The prosecutor really, she did a nice job throughout the day. She got a little too upset that the judge said something obvious, which is this case should have been disposed with motion, and it should have been. The fact that it wasn't a big deal. But then, of course, we have to have Judge McBurney's Boy Scout presentation of the participation awards at the end, which is very typical in these courtrooms. The judges all try to be nice to all the participants afterwards. That's common. It's cringe. It's cringy as hell. I've dealt with it for 30 years. The judges always try to say the nicest things they can to everybody at the end because somebody lost and feelers are hurt and blah, blah, blah. That's just kind of the way it is. It was a lot of fun in a horrible, painful, awful way. Okay, it wasn't fun, but we watched it. We watched it. There it was. The only fun part is that is seeing you guys in chat. Thank you so much. I appreciate it. I will see you soon.